Good day and good morning, honorable members.
Morning, Chair.
I think let's start the meeting, honorable members and the officials that are present with us. And okay, let's start the meeting, honorable members. And start by bowing our heads where we are. Then we'll hear who's in the meeting and who's not in the meeting. But I can see that we are 18 of us that are present. Thank you very much, honorable members. The meeting is officially opened, and I wish to welcome everybody in the meeting. It's just that today, really, one has to try and thank God that she is still alive out of many things that are happening outside. And we also wish all the best for those that have managed to make their lists and those that didn't manage to make it. Let them not despair, but soldier on and work for the communities and for their areas where they were voted for, and not give up and throw the towel. There's always a tomorrow and there's always next time. I understand that this is really a very traumatic period, because every organization and every one of us is wishing for their organization to be the one who has a victory. But in all the situation and also the cases, that doesn't make us to be enemies for now, and that doesn't make us not to work. But I understand that the programs are very tight. We are running like chickens, because we have to work for our organization. So I wish to give you more strength during this period. I also wish you all the best. How I wish that we can again come to this committee and be like a family as we are, and participate and try to deliver service charges and service that are necessary for our people. I understand that we do have manifestos and different manifestos in different areas. All what is being said in these manifestos will do better. So let's do better, as we have promised to communities and also to people of South Africa, and try to do more and more than we have done. I understand that no one will know what we have done and what is it that we are doing in this parliament. But those that are inside the parliament, you know how difficult it is and how hard we worked for the previous term. Thank you very much. And also, we would like to explain to members that our wish as this term, we would like to finish up this bill and at least leave something that we will say when we are not in these committees and when we are not in the parliament. We are able to say the legend that we left behind is this and that and that. So let us be patient, understanding that today it's not supposed to be our meeting, but we have pressed the schedule to such an extent that it allows us to take this bill to the NCOP, and then the NCOP will see on how to move about with it. Thanks ever so much for understanding and also being part of the meeting today. As we used to do, we won't be wasting time talking something that is I will say, not, I don't want to put a very harsh word, but we won't waste time. We will deliberate accordingly as we used to do. Thank you very much. The meeting is officially opened. Can we request Lindy to flight the agenda so that she is able to tell us and confirm the attendance of the members, and then also include the the apologies. There is the agenda, honorable members. Lindy is going to do item 2, which is the introduction of the honorable members that are present, and also the support staff is going to do theirs, or Lindy is going to indicate, and then also include the apologies. Over to you, Lindy. One item today that is on the agenda. It's the briefing from social development.
Chairperson.
Hello.
Chairperson. So
Hello.
I don't know whether it's on my side. There is another background. I don't know where somebody is floating or what's happening, but there's a noise.
Floating.
I don't know if it's my gadget only, but I'm hearing something. When we're talking, it's like somebody was making a flute or what. I don't know.
A flute, né?
It was disturbing.
Yes, we could hear it, Honorable
You
Bilankulu.
could hear it on your side.
So please,
I will try and
check
check
the person desist from that, because it's annoying.
Okay, I will check for that flute, which I don't know what it is. But since I am at home, you might understand that the floats can be coming outside and all the stuff.
From somewhere else, yes, but then
yes,
it was too much.
Okay, no, I will try to stop it and check where it is coming from. I'm sorry for that. I understand the noise is really annoying and also irritates one. Thank you. Let me go and do that. Can Lindy give you over? Lindy, confirm the attendance of the honorable members that are present.
Okay, thank you very much, Chair. Good morning, Chairperson, the members and departmental officials that are in this meeting. Chair, today is the 12th of March 2024. The PC on Social Development is officially meeting in terms of the rules of the National Assembly. Chair, I wish to confirm the following members that are present. I have Member Mvana, I have Member Peterson, I have Member Shongo, I have Member Bilankulu, I have Member Fanda Merve, I have Member Aris, I have Member Mare, I have Member Stock. Chair, I wish to confirm that we are a quorum because we have more than 50 plus 1 members that are present and we can take decisions. Chair, in terms of apologies, I've received an apology from Member Masango, who indicated that she'll be traveling the whole day today and won't be able to make it. Also, Chair, the Minister of Social Development, Minister Zulu, is not with us today. She's out of the country participating in the 68th session of United Nations Commission on the Status of Women in the United States of America. Also, Chair, the acting DG indicated that he will join the meeting a bit late, but he has delegated DDG Ndaba to lead delegation. Chair, we have departmental officials that are here with us. I think Ndaba will introduce when they make presentation. Also, Chair, your full support staff is with us, consists of Yoli, the content advisor, Siavuya, the researcher, also Fungile Bulawa, the comment assistant, and also your executive secretary, Tadima Huwelen. Thank you very much, Chair. Over to you.
Chairperson.
Thank you. Hello.
Chairperson, I just want to make an apology. I will have to. Yes, good morning, Chair. How are you? Chairperson, I want to make an apology. I'm fine, Chairperson, man. I'm going to leave the meeting at 10:30.
Recording in progress.
Because I have another today and tomorrow. So, but I will be in the meeting and then I will have to leave because I have another meeting today and tomorrow with Parliament. Thank you, Chairperson.
Okay, thank you. Understanding fully, Honorable, that Tuesday is not our day for meetings. but at least we will try our level best and check whether at least by the time you are leaving, we have covered a lot of the presentation. I understand that, Lindy, the presentation has been sent to members, at least as to go through, so that at least they have an idea of what has been, what is going to be presented. Thank you very much, Lindy, for those apologies and also the confirmation of the attendance. Then, Miss or Mr. Ndaba, I'm not sure. DDG, we will introduce the officials that are present with us when you are given time to delegate the duties to them. Can we then go to the adoption of the agenda? Honorable Polnit, let's adopt. The agenda is briefing by the Department of Social Development in response to the public inputs on the Older Persons Amendment Bill.
Thank you, Chairperson. I will adopt the agenda, Chairperson.
Thank you, Honorable Marie. You will be excused when the time comes for you to leave. Otherwise, we all understand the apologies will flow and flock together. Thanks ever so much. Then let's not waste time, as I have already indicated. Can we request DDG Ndaba?
Sorry, Chair, for interruption. You haven't get the seconder. The motion
Oh, the
was moved
seconder.
by
Okay, the
Marie,
seconder.
yes.
Can we
I will
get to the
second the-
seconder?
Morning,
beg your-
Chairperson.
Morning.
Morning, Chairperson. I will second the adoption of the agenda. Thank you.
Hello, Aris. Thank you very
It-
much for seconding. Thank you.
Melvin, eh?
Yes. Ongfanda Meve.
Yes,
Chair.
Chair. Me.
Oh, why are your
Morning.
voices more or less similar? Morning. Morning.
Morning.
KZ.
They must take a minute, Chairman.
Sanbonani. KZN.
Award. Okay, thank you very much. Can we then move with speed in terms of giving over to DDG Ndaba, because the agenda has been adopted and then being seconded by Honorable Vanda Meve. Over to you.
Good morning, Honorable.
Okay, please just flight the
Good morning,
video.
Honorable Chair.
Hey, full house. Hey, molweni nonke bethuna niyakhumbuleka kanjani? Miss you all. Ndaba.
We miss you, Chairperson. We miss the whole committee. Good
Okay,
morning,
Ndaba, over to you,
honorable
ne?
members.
And maybe just show your face and then switch off the video. We don't want to see the students that are seated there for the exams.
Thank you,
Okay.
Honorable Chair. Thank you, Honorable Chair and honorable members. Greetings to you. We are ready. The team is here, as you can see. Advocate Mchochisa will introduce the issues, and then Civil will take over after Advocate Mchochisa. The rest of the team will respond to the questions when it is time to respond to questions. We will now share the presentation, and then I will ask Advocate Mchochisa to lead us on the presentation. Thank you very much.
Thank you very much, Mr. Ndaba. Then let's give over to Datu Mchochisa. You are delegated to assist us.
Through you, Chair, I didn't get the person that will be presenting so that I can give him or her sharing rights. Who must I give the sharing rights?
Datu Mchochisa, it said it's Datu Mchochisa and will be followed by 7.
So sorry, Chair, we are operating from one boardroom. So can you give the sharing rights to Kumbula Ndaba? And then Mchochisa is going to introduce our issues, followed by
Okay,
7.
Kumbula, I know your
Kumbula
name,
Ndaba.
but not your surname. You will
Umbulanda.
be the co-host, yes. Thank you.
Done?
Good morning, Honorable Chair, Honorable members,
Good,
colleagues.
good morning, Advocate Mtshotshisa. Igqwetha lethu. Nkosi.
Thank you, Honorable Chair. I will just be taking the first few slides just to introduce the issues, and the policy issues will be dealt with later by Ms. Civil Devoto, as has been indicated. Just to indicate, Honorable Chair, that the purpose that brings us here is to respond to matters that were raised during public hearings on the Older Persons Amendment Bill as outlined by our Content League advisor. Just to indicate, Honorable Chair, that there are matters that have not been gazetted, which featured too much during the consultations that we had during the public hearings. So in responding to the issues raised during public hearings, focus shall only be limited to matters that were gazetted, because it will be unprocedural, to deal with the matters that were not gazetted. And
Excuse me, Advocate. I'm sure you are just doing the, what is it, the background or but in a preamble, because we don't see anything that you are going to present in the screen.
It's not like that.
And they have been given to Umbula.
My apologies, Honorable
Maybe it's
Chair.
the preamble for the advocate. We don't worry about it, but let's rather get the presentation. Thank you.
My apologies, Honorable Chair. I was of the view that it's on the screen, but it's being sorted. I would just ask for a minute. Good morning once again, Honorable Chair. Just to indicate if the matter is on the screen now.
Yes, it is on the screen. I think you can proceed.
Yes, we are able to see it, but it has, yes, that's it. Thank you.
Okay, thank you, Honorable Chair. As I was indicating, that the purpose of this presentation is to respond to matters that were raised during public hearings on the Older Persons Amendment Bill as outlined by the Content Advisor. We must indicate, Honorable Chair and Honorable members, that in responding to issues raised during public hearings, focus shall only be limited to gazetted provisions. We must be mindful of the fact that there's so many issues that were raised during these public hearings, which do not necessarily fall within the scope of this bill that we are presenting, which is usually the case when we deal with public hearings. But for the purposes of doing justice to the bill, we'll focus on the matters that were raised, which relate to the clauses that were gazetted. The rationale for that, Honorable Chair, Honorable members, is that it would be unprocedural to people out there would have perhaps had different views if such matters were gazetted for all to opine thereon. So entertaining the few that were raised would then not be reflective of the will of the masses, as most people would not have had an opportunity to give an opinion thereon. There are also matters, Honorable Chair and Honorable Members, that belong to other organs of state. That is the intersectoral issues. We must be mindful of the fact that some of the issues that were raised are actually managed by other departments or dealt with or administered by other organs of state. So in that way, we must also indicate that these have also been excluded from the responses, but we do have to say a word or two about how we will deal with those matters, but they have actually no bearing on the bill itself, as we would be legislating for other departments if we would entertain those. So the department, and we shall address such in other platforms, as addressing them during this session would likely extend the scope of this bill that is before the committee and impact on the mandate of other organs of state who may not have had an opportunity to present their cases before the committee. And those matters actually fall within their purview in terms of their legislations and not necessarily us. And also, Chairperson, we need to put this in perspective in terms of how we responded to the matters that were raised. Taking a cue from international law in the beginning to say, if we look at the Constitution in Section 39, it does indicate that when interpreting the Bill of Rights, a court tribunal forum must consider international law and may consider foreign law. So we look at what the foreign law issues are saying when we try to respond, because we are part of the global community. When we speak of the protection of the rights of older persons, what is the United to domesticate such issues in our own space? So at the end of the day, we need to be mindful of the fact that we do not necessarily look at the comments and reject them for the sake of rejecting them, but we are guided by the principles enshrined in the international law space. And again, we also consider foreign law if it comes to a push where there is a lacuna in our position. For example, if the team may have gone for a study tour and all the lessons that were learned during that session, and if they've got a bearing in this particular bill, then those will be considered in the context of what Section 39(1) of the Constitution says, that we may consider the foreign law. Again, Honorable Chair, we need to be mindful of the fact that there are issues that were raised that relate to other organs of state, as I've just indicated. If one can look at what the Domestic Violence Act is saying as presented by the Department of Justice, you will take into account that the Domestic Violence Act already covers some of the concerns that were raised by members of the community out there, because it does provide for the fact that if one can apply for a protection order, one can apply for a protection order in terms of the DVA, it is not necessary for us to repeat that law in this legislation, because this matter is already covered there. Because the Domestic Violence Act, as amended, Honorable Protection Order, if one is abused by somebody with whom one is in a domestic relationship, one can also apply for a protection order on behalf of someone else who is a victim of domestic violence. And also any person who is concerned that someone is being abused, including a social worker, teacher, a health worker, or police officer, they've got a duty to report such abuse. And that legislation is already covered that issue. So we do not necessarily need to provide it in this particular legislation. Again, if you look at the regulations to this particular legislation, It says an adult person who knows, as I've just indicated, believes or suspects on reasonable grounds that an act of domestic violence, which includes the abuse of the elderly, has been committed against a child, a person with a disability, or an older person, which is our emphasis, as soon as possible, report such knowledge, belief, or suspicion in the manner that is contemplated in those regulations. That is what is indicated. There is also an issue about the slide that relates to the prevention of and treatment for substance abuse legislation. We will also have taken into account that during the public hearings, many older people were indicating that they are being abused by their grandchildren who are on drugs and all that. And there is a piece of legislation that deals with that in the department. And we cannot also take that into this particular bill because it's already legislated in one of our pieces of legislation. So this, Honorable Chair, is which was a comment that came across, the comment that came across throughout the country was the issue of older people who are, the service providers who are individuals who are prohibited from running or rendering the services to older persons, which is a concept that may have been misconstrued because in terms of in terms of what the bill purports to achieve, that is natural versus touristic persons, in terms of what the bill seeks to achieve is to ensure that the services are provided on continuous basis, the manner in which they to be interrupted. So the sole proprietorship is not a legal entity. The business has no existence separate from the owner, who is called the proprietor. So the owner must include the income from such business in his or her own income tax return and is responsible for the payment of taxes thereof. So there is a challenge with regard to operating a business as a sole proprietor that is rendering services to older persons as a sole proprietor, because if this sole proprietor, say for argument's sake, dies tomorrow and is married in community of property, then the half of the estate will belong to the surviving partner. So in that way, there will be a challenge because half of the estate will also include the monies that were paid by the older persons as service users that were provided by the sole proprietor. So it's not that the department is saying natural persons must not provide services. It is actually saying it is disadvantageous for natural persons to do so because of the implications that this might have once a natural person dies or the natural person is divorced. Then the monies that were paid by the service providers will be affected in that way. But if the person is operating as a juristic person, the juristic person does not cease to exist solely based on the death of a partner, but it will, or the death of the service provider itself, it continues perpetually. And that is what we want to see at the end of the day. What we actually advise is that if by any chance an individual wants to provide services to the older persons, it is encouraged that that particular individual forms something like an entity which will be a juristic person in nature, so that at the end of the day, these services are not interrupted when the person, say, dies or ceases to exist. It is in the same context that I also provided the information around the prevention of and treatment for substance abuse, where we indicated that department is already providing services to children who are abusing substances, or to persons who are abusing substances on an involuntary basis, in order to ensure that the older persons are not affected by the behavior of those who use substances. It's a question of awareness raising, Honorable Chair, that we may need to intensively embark on as a department, because some of the challenges that were brought to our attention during the public hearings are already catered for in other pieces of legislation. So in responding to the comments that were made, we will not be dealing with such issues that are already covered in other pieces of legislation within the department, and that are also covered by other pieces of legislation in other pieces of legislation in other organs of state, like the indigent policy that you always made reference to, which is taken care of by another organ of state. So we'll be focusing on what the comments be dealt with and how we should indicate how we are going to be solving such challenges. On that note, Honorable Chair, I will take a pause and hand over to Chief Director Similoho to take us through the comments bit by bit. Thank you.
Thank you very much, Advocate Mthethisa. Let me take this opportunity to greet your Honorable Chairperson, as well as the honorable members of the Portfolio Committee on Social Development. I am going to proceed from slide 11, which covers the first submission, which was made by Prof. Kitty Malherbe.
Excuse me, presenter. Can you come closer to the mic, because you seem not to be very audible? Come closer to the mic. I understand that you are sharing the gadget since we are in the common venue. Thank you. Over to you.
Thank you very much, Advocate Mthethisa. Let me greet you, Chairperson and honorable members of the Portfolio Committee on Social Development. I am going to start responding from the submission that was made by Prof. Kitty Malherbe and others, which is slide 11. Chairperson, the stakeholder grouping indicated the lack of clarity, and they mentioned that the spelling can be easily confused, and that there's also no clarity of the reason for the definition of caregiver and why it is limited to qualified persons accredited with an NQF training qualification, providing care and support services at community-based care facilities, residential facilities, or similar facilities. Only this definition will exclude members or any formal support to the older persons. And we are saying, Chairperson, in this regard, the proposal should include family members or any informal support that is being provided to older persons without training. And we are saying this proposal is not supported, specifically because the definition in the Principal Act includes any person who provides care to older persons, and it does not necessarily exclude family members. So as a result, the proposal is not supported. There is an additional recommendation which states if caregiver and caregiver are truly intended to be interpreted differently, a definition of caregiver should also be included with an explanation of the context in which it applies. We submit that, Chairperson, the definition is not part of the bill, and therefore the proposal to define caregiver is also not supported. The other submission is that the bill neglects to sufficiently address the multi-level intergovernmental relations between national and provincial social development departments. And we are saying the issue of intergovernmental relations was raised by various stakeholders across various provinces during the public hearings. And in this regard, the Principal Act also has already catered for intergovernmental relations through defining the powers of the MECs and HODs and further unpacking the delegations to officials in the other spheres of government. The other submission is that clarity was sought in terms of the extent to which stakeholders are using the maximum of their available resources in the promotion of the interests of older persons, and a need for this to be measured was also proposed. So we submit, Chairperson, that maximum carries its ordinary meaning in this regard under these circumstances, and that ordinarily the Act provides that the Minister must, from the funds appropriated for such a purpose, provide for the activities as contemplated in the Act. The implication, therefore, is that all monies appropriated for that purpose must be fully utilized to achieve such a purpose. The other recommendation submitted is that they propose that a uniform approach aimed at integrating and coordinating services to older persons can be achieved if national and provincial departments cooperate and coordinate their implementation of the older persons in different legislation. We submit, Chairperson, that the proposal is already covered in the Principal Act number 13 of 2006, and in the bill under section 3.3. And this will further be dealt with when we develop the regulations that are going to be supporting the implementation of this legislative framework. The proposal to address the issue in different pieces of legislation, Chairperson, is rejected specifically on the basis of what Ubaba Mtshutshisa already indicated, because it will also result in the department exceeding on its mandate, and it does not have the powers to legislate for other organs of state, as stated earlier by Advocate Mtshutshisa. Now, there's also a submission relating to the heading of Section 7A, introduced by Section 6 of the bill, which suggests that we rephrase the heading along the lines of recognition of older persons' role in their communities. The current rephrasing, responsibilities of older persons, is inaccurate, as it does not correspond to the text of the section, which aims to ensure that older persons are not prevented from fulfilling their crucial roles in society. So this proposal is also not supported, Chairperson. The proposal is supported, Chairperson, because the heading shall remain the same, but the content will be rephrased in order to be in line or in alignment with the obligations for older persons. So we do support the proposal. In terms of the submission relating to Section 25(5)(a), which refers to an old age grant instead of the grant's official name in terms of the Social Assistance Act number 13 of 2004, which is Older Persons Grant. The recommendation is that the bill should address the discrepancy by introducing an amendment to Section 25(5)(a). So we submit, Chairperson, that despite the fact that this was not gazetted, the proposal is supported. Our reason for supporting the proposal is linked to our continued endeavor to ensure the alignment of all our legislative frameworks. And in this regard, we stand to be guided by Parliament as to whether we can also amend this part, as it is not substantive, but more administrative in nature. There's another submission relating to the definition of a person or juristic personality, which Advocate Mtshutshisa has just unpacked. And we say, Chairperson, if only juristic persons can register and operate as and provide services to older persons, Section 31(2) will be rendered meaningless, a person at a juristic person refers to a manager of a particular facility. So we align ourselves with what the advocate has already submitted relating to defining and the juristic person as well as the natural person. And so this matter we have already addressed in the earlier slides, Chairperson. I'm not going to belabor it. There is also a submission relating to the insertion of 25B to Section 15 of the Act, where it states that no definitions are provided for family care and special care. So, Chairperson, the proposal is supported, and we accept that we have defined family care and special care in the matrix that we have shared with the Portfolio Committee. So our response, Chairperson, is that Section 3 of the Principal Act calls for all organs of state to implement the Older Persons Act, and that is an obligation. But it is also a gap that we identified when we conducted the implementation evaluation of the Older Persons Act a few years ago. So the Act provides for funding of service providers in order to create more access to services by our older persons. And we further state that on an annual basis, the Minister, through funds appropriated by Parliament for that purpose, provides for funding of service providers in order to create access to older person services and related programs. With regard to the submission by Rand 8 Association and others, the organization noted that in the memorandum, it is mentioned that it was consulted, but that is not the case. It only submitted comments. It was never consulted on the proposed amendments, and it wants to put this on record. We submit, therefore, Chairperson, that there is a misunderstanding in terms of reading the gazetted bill, because the bill differentiates between stakeholders that were consulted and those who submitted comments following gazetting for public comments. So the bill can always be accessed online to confirm that Rand 8 falls within the list of those who submitted comments and not those who were consulted. That is how we have enlisted Rand 8. They further state that the bill, despite its noble intention, may have unintended consequences as it puts more focus on registration and control of all types of services and even accommodation options where retired people invested their own funds and opted to leave. So, Chairperson, we submit that in terms of section, everyone has inherent dignity and the right to have their dignity respected and protected. So in this regard, it is immaterial of whether the retired people invested their own funds or the state subsidizes service providers for ensuring such protection. And therefore, it remains important for all of us to note and take cognizance of the fact that the state has a duty to ensure that the inherent dignity contemplated in the Constitution is protected at all times. And that includes the rights of older persons and their inherent dignity. Emphasis here is that the Constitution is not selective in terms of such protection and does not discriminate in terms of where older persons are residents, and therefore the provision therein is couched to include, to mean everyone. The association further states that the country has a growing older population and is in dire need of support and accommodation. Thus, the focus should be on creating an enabling environment that would encourage service providers to develop and implement a wide range of services by giving support and services. We note the comment and appreciate this submission, Chair, but it should also be noted that the Act promotes that older persons should remain within their own communities for as long as it is possible. And Chapter 5 of the legislation effectively deals with the importance of the provision of community-based care and support services to older persons. And the reason, Chairperson, that we are now putting more emphasis on strengthening and promoting community-based care and support services and programs is because of the growing number of older persons in the country. We are now standing at 5.6 million of older persons, and therefore residential care facilities will not be able to cope with taking care of our older persons if we are not going to strengthen community-based care and support services. So our programs need to respond to their needs and importantly ensure that there is collective preparedness for the reduction of the burden of disease, as we are now starting to have more centenarians. The second issue that they are submitting is Honorable and Frey are cared for on a 24-hour basis, and that it is understandable that government subsidies necessitate certain controls and requirements, but these do not have to be legislated, as they can be conditions of financing, such as the number and type of services to be provided, whether it is a 24-hour facility or a home-based care program. And in this regard, Chair and honorable members, we submit that it is immaterial whether you are subsidized by the state or not. The state has a duty to ensure that older persons are protected in all these institutions which they occupy or receive services and programs from. The association further states that it fears that the bill criminalizes all unregistered community-based services and housing facilities and developments, and that when read together with the existing norms and standards in the regulations, OneRA's demands are placed care and support services, and it is not clear why housing developments for independent older persons, which are already regulated by other legislation, are included for registration in terms of the bill. And we submit, Chairperson, that the rationale for registration is for the protection of the rights and the dignity of older persons, and therefore it does not constitute criminalizing such organizations. We also state that it is immaterial of whether the service provider is already compliant with other pieces of legislation or not, because each legislation has got its own purpose. But this particular bill intends to ensure the protection of older persons wherever they are in the Republic. And registration will also assist us in terms of making sure that there is regular monitoring of the persons continue to receive across such facilities. The association also argues that if measures to hold liable those who abuse and exploit older persons were taken seriously, are adequately and efficiently implemented, it is not necessary to register each activity related to older persons. And the further states that grouping housing developments for independent older persons with residential care services will create confusion. It argues that this approach makes housing developments subject to the norms and standards for residential facilities, which were drafted with 24-hour frail care facilities in mind. The norms and standards cannot be applied to housing developments such as retirement villages because they are governed by sectional title legislation or were sold on a freehold basis. It further submits that some of the proposals regarding housing facilities encroach on the right of older persons to make decisions for themselves and lead independent lives. And we say, Chairperson, this view is not correct, as the sole purpose of the bill is to ensure compliance with legislative prescripts that seek to ensure the protection of the rights of older persons and the upholding of their dignity and integrity. And the association further submits that the bill creates unnecessary blanket action relating to any kind of service to older persons. It recommends that the bill should create an enabling service environment without contradictions and inconsistencies. It also questions how the department is going to register all housing developments and community-based services in addition to the workload of registering and monitoring 24-hour frail care facilities, when it is already under strain. It points out that it took more than 10 years to register the 24-hour care facilities for older persons, previously old age homes, and many of the provisions in the 2006 Act remain outstanding. For example, the issues of registration of care workers. So we say the department has got a very clear implementation plan for the legislation in question, and the absence of capacity in the department cannot be a bar to allow lawlessness by our service providers. So there's a further submission in terms of costs, that the costing of the bill was made 5 years ago, that is in the financial year 2017-2018, and that there has been recent subsidy cuts in Gauteng, and it impacts on COVID-19 pandemic and load shedding on the economy. How is the bill envisaged to be covered? It questions if it is envisaged that the number of staff in the department will be increased to meet the requirements of the proposed amendments, and will such an increase in staff impact on the funds available for the subsidization of NPOs providing essential care and protection services. And Chair, we submit that this bill was costed, and when it was costed, it was borne in mind that the implementation of the finalized product, namely the Amendment Act, will have to take an incremental approach, as it will always envisage that the costs are not static and would need to be reviewed from time to time. So the costing model for the legislation would be cognizant of the initial stage of implementation, the transitional stage, and the time at which full implementation takes place. So it must therefore be noted that the approach that it adopted in costing legislation is futuristic in nature, and the costing of this bill has therefore not been exempted from that. There was an omission in that regard, Chairperson, so we are submitting that this bill was not exempted from the futuristic approach in terms of costing. An additional submission is that there are restrictions on service developments. The association argues that the Act is supposed to encourage service delivery to older persons, and that by implementing all these requirements for registration and control, as well as detailed operational standards determined in the regulations, it becomes more difficult, almost impossible for service providers to develop and implement services. It also questions why in community services, services such as recreational, information sharing, spiritual meals, and intergenerational programs must be registered. Regulations contain strict criteria of how many primary services must be registered. What is the purpose of these restrictions? For example, a church operating a soup kitchen in a poor community. Currently, this is illegal if not registered, leading to older persons missing out on assistance and support. And subsidy criteria should not be applied in a broad brush approach to all service support services. It foresees that the same will happen with housing developments. Chairperson, these issues that I have just read out have also been addressed earlier. We talked about issues of registration earlier. So this is a repeat of what was raised in the earlier slide. The association further states that the organization makes reference to the Housing Development Schemes for Retired Persons, Act number 19, Act of 1988, and it submits that reference to an inclusion of housing developments governed by this Act should be reviewed. It raised the following contradictions and inconsistencies. Do all housing developments fall under the auspices of the Older Persons Act, or only those that cater for persons 60 years and older? What happens in the case of developments where people younger and older than 60 are catered for together? So Chairperson, we're saying it appears that there is a contradiction on this comment because the legislation refers to retired persons who would ordinarily fall within the ambit of the Older Persons Act, as this is our primary focus. If the retirees are younger than 60 years, they do not fall within the ambit of the Older Persons Act. But the facility that caters for them has got to comply with the Older Persons Act if its intention is to provide services to older persons as defined. There is also another submission which states that it is inconceivable that the minister can have the powers to close a housing development operating in terms of a sectional title scheme, share block, freehold, or life rights development. What happens to the capital invested by the older persons in their own privately purchased house, flat, apartment to which they may hold a registered title? Is it envisaged that the minister be empowered to take away property rights? It is not about sectional title schemes, shared block, freehold stands. It is about the activity that takes place therein, Chairperson, which empowers the minister to intervene in an event where the rights to human dignity of an older person is at stake. That is our submission, Chairperson, in this regard. There is a further submission from Rent Aid Association, which talks to the issue of assisted living facility. It states that the organization questions the use of residential facility in the definition of assisted living in relation to the definition of residential facility, referring to 24-hour care and accommodation and provision of services. The bill defines care to include physical, psychological, social, spiritual, nursing, first aid, or material assistance. Thus, this cannot be the intention for assisted living. The organization argues that this is an example of overreach of this proposed definition. The department submits that it is not in agreement with the comments that have been submitted by Rent Aid Association in this regard, because all these services can still be accessed in an assisted living facility. The association further questions the intention of safe and accessible in the definition of assisted living facility. Is it related to security? Is it accessible to disabled persons? Is accessible used in relation to affordable? So we submit, Chairperson, that the definition is intended to protect the rights, the dignity, the safety, and the security of older persons, and not to ensure that services are accessible, irrespective of whether they are affordable or not. There's a further submission relating to care, where the organization states that the broad scope of the definition of care has a serious impact on other definitions and services, for example, the caregiver. And there's a further submission that due to the broad definition of care, it becomes problematic to determine who is regarded as a caregiver. And for example, due to the inclusion of spiritual care, is the intention that a priest should be regarded as a caregiver? Similarly, with nursing, is the nurse a caregiver? Also, will social and psychological support imply a social worker or a therapist is a caregiver? And we are saying, Chairperson, the proposal is supported. The intention of adding spiritual, nursing, first aid was not intended to, but it was mainly to provide for a holistic basket of services to older persons. We have thus removed such words in order to avoid the confusion that we see comes with the initial definition. The organization has also submitted that if 24-hour care is deleted from the residential facility definition as it proposes, then the definition of caregiver needs to be expanded to include frail care facilities. And we are saying, Chairperson, 24-hour care is not deleted from the residential facility definition. Instead, the provision has been rearranged to avoid the tautology that was picked up. The organization further questions the independent living defined as fully independent. Why is the broad definition of residential facility used that includes independent living in the definition of the caregiver when a caregiver will not be needed by an older person who is a fully independent active person? We say, Chairperson, in this regard, the nature of services provided in a residential facility is a broad range of basket of services, which are not only limited to care, but can include support services, which can also be accessed by all older persons, irrespective of their level of independence or dependence. The association also questions what is meant by similar facility. It also appears in a few other definitions. If it is not known, it suggests that it should be deleted everywhere it appears. We say in this regard, the term similar facility carries its ordinary meaning. It is included in this bill in order to close a gap that has been identified where people render services to older persons in environments that may not necessarily be regarded as residential facilities, but the nature of the services are similar to those rendered in a residential facility. For example, within a church facility or within a VEP shelter. There's a further submission relating to frail care facility where the organization points out that the definition also describes frail care facility as a residential facility where primary 24-hour services are provided to frail older persons. It recommends that 24-hour care service be deleted from the definition of residential facility. So we submit, Chairperson, that this view is incorrect because the nature of services that are provided in a residential facility or anywhere where an older person is involved are provided on a 24-hour basis. And there is no way where we can remove a 24-hour service in a residential facility because the removal of an older person from a facility without a court can happen at midnight or any time of the day for that matter. So we would like to retain the position that we have in that regard. A further submission relating to independent living facility is that independent living is defined as a residential facility that provides accommodation to fully independent, active older persons. It then questions if the intention is that no care must be provided or an older person may not age in place as it is the norm worldwide. The agency of an older person is thus taken away in this bill. And we're saying, Chairperson, it sounds like the definition of care is being limited in this regard. If we go back to the definition of care, one would notice that it is broad enough to include services that can be offered to all older persons, irrespective of whether they are in an independent living facility or not. There's a further submission by the association that relating to interdepartmental structure, the organization poses these questions. Why is it needed? What has happened in the past with cross-departmental responsibilities? Is this not covered or guideline? Who is to establish this? More importantly, how can an interdepartmental structure include a civil society organization and any person? Is this a natural person or again a juristic person? It seems strange to involve natural persons here, but not allow them to operate any facilities. If this remains, who and how will these persons be chosen? And we are saying, Chairperson, this structure is needed because the nature of services requires integration. One of the areas of weakness of the Principal Act was the lack of integration, the lack of coordination, as well as collaboration and intergovernmental engagements. And in this regard, monitoring of the Act was also found to be on the weak side, and this affected all organs of state, and it impacted negatively on the implementation of the Act. And this is one of the findings of the outcome of the implementation, the assessment of the implementation of the Principal Act. So we are saying the comment relating to the inclusion of civil society as part of the interdepartmental structure is noted, and it has been addressed. There's a further submission relating to manager. The organization questions the intention of the proposed definition. Is it for the management of a residential facility or similar facility, an institution? Both terms are not defined, or any program for rendering services. This has a very broad definition in the 2006 Act, any activity or program to older persons, even a recreation program. So we say, Chairperson, in this regard, the word manager carries its ordinary dictionary meaning. That is why it has not been defined as per the rules governing definitions in this legislation. If we were to limit or extend or restrict the meaning of the word manager, then we would need to define it. How it is not clear what exactly is the confusion when it comes to the understanding of the word manager. Now, there's a further submission relating to person. The organization argues that the proposed limitations in respect of registration and operation of community-based care and support services, home-based care and residential facilities to mean only a juristic person or a trust will be extremely limiting to any individual who has or would like to provide any support services to older persons, such as running a soup kitchen or providing a recreational service. And we are saying, yes, the department agrees that this can be limiting to any individual as indicated. However, the explanation regarding the rationale for limiting the provision of these services to juristic persons has already been provided for earlier by Advocate Mshochisa. We also have a submission from the association relating to private residential facility, which states that the organization questions the intention or the proposed requirement for registration of this facility when the HDSRP Act does not provide various ways of operating a development scheme in terms of this Act, but no central register exists because of this fact. If developed, for example, as a sectional title scheme, the scheme will be registered in the relevant deeds office registry, or if a share block scheme, it will be at CIPC, which refers to Companies and Intellectual Property Commission. Now we say everyone involved in the provision of services to older persons has a responsibility to register. And the rationale behind this expectation is that in case something goes wrong within that particular space where services are being rendered to older persons, the department has a responsibility to also account, as it is the custodian of the register for such. It does not necessarily need to be a central register as the provinces have service providers. It therefore follows that each province will have its own register. However, in the event of a need for a central register, the National Department of Social Development may have such a central register. Now, there's a further question which says, what is the difference between private residential facility and independent living facility, as both encompass accommodation, housing for independent older persons? In the contention that only those facilities governed by the HDSRP are private and the other run by government, that is not the case, as most of the independent living facilities were established by private groups such as the NPOs or developers. what is meant by private. And we submit, Chairperson, that there is no difference as long as they are not owned by the state. Those that are owned by the state remain to be referred to as public facilities. The organization points out that the proposed definition refers to a building or a structure that is used primarily for the 24-hour care, etc., and includes both public and private residential facility as defined. And it further questions how is primary for 24-hour care compatible with assisted living and independent living, both used in the definition or residential facility. And Chairperson, we've already responded to this particular issue by indicating that it is immaterial whether it's a private residential facility or not. What is key for us is that the services are provided over a period of 24 hours in a particular day. So the organization further submits that reference to public and private residential facilities in this definition is problematic, as the term being defined is used in the definition of the same term. It seems the definition also covers a private residence where an older person will be accommodated and is provided with services. Is this why a private residential facility is defined as established or registered in terms of the SRP Act, but then every house or cottage or unit in such a development must be registered? Again, surely not the intention. And we say, Chairperson, the definition is not problematic, as a clear distinction is drawn between private and public residential facilities as articulated earlier on. A further submission relates to section 18(1)(b) in terms of the exclusion of private residences where an older person is looked after by a family member. And the association indicates that it's unclear how this can work when this act already provides under section 5 that care facilities in a housing scheme should be registered as a home of the aged as defined in the Aged Persons Act of 1967. And we are saying, Chairperson, the Aged Persons Act as amended was repealed in section 35(1) of the Older Persons Act. The stakeholder submission by Rent 8 also states that the organization is questioning this definition as it is government's responsibility to look after citizens and their rights as stated in the Constitution, Article 7.2. The association argues that the burdens imposed by the bill on stakeholders are cumbersome, and it is almost as if it is expected of them to undertake the duties imposed on government. There's also a principal issue and dichotomy. Private persons are regarded as stakeholders with wondrous duties, but they are not allowed to deliver services. We have already unpacked this, Chair. It continues to repeat itself. There is also a submission relating to temporary safe care. The organization questions what will happen after 6 months has lapsed of the temporary safe care. Can the period be extended if the circumstances warrant it? It seems this has not been thought through, as was the definition in the earlier bill. And we say the idea is the placement must be temporary and the solution must be reached within the limited period of 6 months. And the rationale is that the department does not want a permanent institutionalization of the situation. However, if circumstances warrant extension, that can still be considered with conditions attached to that consideration. And that there must be an intervention plan that will be shared at the point where extension is granted to avoid unwarranted permanency. Under section 2, the organization questions why people with disabilities are not granted the same protection. There is no act to regulate residential or non-residential care for disabled adults. We say, Chairperson, this view is not correct. because the Constitution is clear in Section 9. It states that no one may be unfairly discriminated based on the grounds of disability, amongst others. There are also many pieces of legislation. The Department of Social Development is in the process of finalizing a policy that deals specifically with issues relating to persons with disabilities, which also echoes the importance of mainstreaming services to persons with disabilities. And the Constitution is also very clear that the rights enshrined therein are for everyone, and the word everyone includes persons with disabilities, and therefore they are granted the same protection. The association further states that Section 3.1 stakeholders are not to implement the Act. This cannot be the intention. They are, however, to comply with all relevant legislation, and that should be monitored by the organs of state. And it further repeats the same, where stakeholders in the private sector are already stretched to maximize positive impact for older persons with limited state financial support. It is illogical to enact legislation to impose duties on the private sector to achieve the objects of the Act. Further submission is that duties can only be imposed where the state funds the private sector to implement certain programs and services. The private sector operates voluntarily, whether on a non-profit basis or for gain. We submit in this regard, Chairperson and members, that this is not about funding. The state has a responsibility to protect the dignity of the older persons as per the Constitution. So it is immaterial whether the state funds the facilities in which older persons are resident or not. Their protection remains the primary, where they receive services remains immaterial. Section 3.3, there's a reference that this amendment is too prescriptive. How is it envisaged that this uniform approach is to be applied? Will it be monitored? If so, by who? And we say, Chairperson, this uniform approach will be monitored by the state. The issue of uniformity has been an outcry for very many years within the social development sector, also coming from the NPOs themselves. We all have a recollection of the Nawongo matter. And this legislation is therefore trying to streamline the provisions of services to older persons, and all stakeholders must therefore be compliant in this regard. A further submission relates to Section 3.4 as prescribed, which states what are the as prescribed. Should the departments not be doing this in any event in terms of the Constitution, specifically referring to Articles 85 and 125 and Chapter 3 of the Public Service Act? And in this regard, we say as prescribed means that the provisions will be unpacked in the regulations, as legislative drafting does not allow us to unpack the how aspect of the provision of the Act. There's a further reference to Section 3.5 on provident as per comment in 4 above. What is meant with provincial plans? Or is it meant to refer to provincial programs referred to in the regulations of the 2006 Act? We say the section is self-explanatory and further strengthens the importance of joint planning, collaborative approaches, and intergovernmental relations and partnerships. So it is an extremely important section for us, because without the support and commitment and buy-in and participation of other government departments, we will not be in a position to effectively and optimally implement this legislation. A further submission relates to Section 4. The amendment is not the place for stakeholders. This is to confirm the responsibility of the state and its organs in relation to older persons and how to protect them and promote their rights. it is covered by Section 5.2 of the Act. We note the comment, Chairperson, it is our submission that, however, everyone to ensure that the rights of older persons are protected. In terms of Section 5, the association states that the amendment is not the place for stakeholders, which is also a repetition of the initial submission, and that the implementation remains the responsibility of the state and its organs. And due to the wide definitions of stakeholders and services, one can even go to the extreme to infer that the retail sector, banking sector, tourism sector, etc., who all have programs for older persons, should base their decisions on the guidelines of the Act and be responsible for its implementation. It is already covered under Section 5.2 of the Act, and we say we note the comment. However, everyone that is involved in the provisions of the services to older persons has a duty to ensure that their rights are upheld and protected. Now, under Section 6, in terms of the insertion of Section 7A and 7B, Section A, the association states that the heading and introductory line does not make sense. How can an older person be denied the right to be responsibility of older person as in the heading? There are good suggestions to be included in a charter, policy, or a plan. What must the older person mediate, or which conflicts are they responsible to resolve? We have tried to unpack this submission, Chair, and we noted the comments, and we also unpacked and addressed this in the metrics that we have submitted. So in terms of Section 7B, the question is why the inclusion of based on gender in older persons. And we say the term based on gender has been included in order to ensure that various accusations, mainly based on gender, do not find application once this bill becomes law. Due to issues of patriarchy, older women and LGBTQIA+ often find themselves being victims of witchcraft accusations or such other myths. So the issue of gender is also promoted because of the challenge relating to gender-based violence and femicide, which is a pandemic in the country. The further submission is under Section 7, amending Section 11, and the association states that it is only non-communicable chronic diseases. Why not all non-communicable diseases or all diseases? What is the reasoning? Is the proposed Section 25B, the heading refers to older persons with disability and chronic illness? Is a chronic illness the same as a non-communicable chronic disease? And we say we note in the comment, and we have further unpacked and addressed this matter in the metrics that we have submitted. In terms of Section 8, amending Section 13, the association submits that the definition of person refers to not only community-based care and support services, but also home-based care and residential facilities in relation to the registration and operation of all these. And the question is there not duplication and or contradiction, or wider and more limiting in different areas? And we say there is no duplication or contradiction. As earlier articulated, the distinction is simply drawn between the natural and the juristic person, as articulated earlier. A further submission is that whilst one object of the Act is to promote the well-being of older persons, here the Act takes away any initiative an individual or religious group or body of individuals might take to assist in enhancing the well-being of an older person or delivering a service to an older person. Is this the object of this new section? it does not make any sense, many with devastating implications for probably hundreds of older persons, where the cost of registering and managing and running a trust or juristic person considered in formulating this proposal. Should registration of community-based services not only apply where state funding and subsidies are sought? We say the matter has been addressed earlier. The state has the responsibility to protect the dignity of older persons in whatever facility or environment, whether funded or not funded, where older persons find themselves receiving services from any provider of services. There's a further submission in terms of Section 9, amending Section 14, which states the prescribed training remains uncertain. Are the different curricula already approved? Where can it be obtained by SAQA? Is there a central register? Is it accessible electronically for ease of all stakeholders? We say the prescribed training is part of the Principal Act, number 13 of 2006. It has not been gazetted for commentary, nor is it part of the bill. It would therefore not be prudent to provide a response relating to this, save to request that any interested stakeholder to visit the department in relation to this, because the prescribed training does exist and the curricula is already approved and it can be obtained from the department or its website. A further submission relates to Section 10, amending Section 15. The submission is that this section is not clear. Section 22 in the 2006 Act implies the monitoring of registered residential facilities, not even evaluation of community-based care and support services is subject to this section. And to the extent that this section applies, it has the effect that none of the community-based services can be monitored in terms of Section 22 or the new Section 15. This view is not correct because community-based services can be monitored in terms of Section 22 of the Act as contemplated in Section 15, which provides as follows: monitoring and evaluation of community-based care and support services. Now, Section 22 respect of the monitoring and evaluation of community-based care and support services as well. A further submission relates to Section 11, amending Section 17. Section 17K does not make sense where there is reference to specialized care in the case of assisted living, where one considers the current proposed definition of assisted living. What specialist care is provided in assisted living facilities? And we say we have noted the comment and the submission is appreciated, and we have addressed this in the matrix as indicated earlier. In Section 17.1, there appears again the term safe and accessible, and the organization is asking, what does that mean? So we say the comment has been noted and appreciated, and it has also been addressed earlier in the presentation, as this is a repeat question. In terms of Section 12, amending Section 18, this subsection also includes the very wide wording of or similar facility. What does this mean? The comment is noted and appreciated and has also been addressed earlier in the presentation. A further submission is that it does not make sense where there are already so many prescriptions relating to planning, development, and building that the Department of Social Development now also needs to participate in the process of providing housing and accommodation. There's a general need for housing in the country, and it should not be planned to make it even more difficult to develop housing. And we say we note the comment and appreciate the submission, However, it is not correct that the Department of Social Development wants to participate in the process of providing housing in the country. However, it must be noted that it is the duty of the department to protect the dignity of the older persons wheresoever they are accommodated. The department is mindful of the fact that the planning and development falls outside its mandate, as earlier indicated, and that, but be that as it may, the department is empowered to ensure that the building that is occupied by older persons remains conducive to their safety and their security, so that protection and that their dignity can also be upheld whilst they live in such a facility. A further submission relates to a trust or a juristic person to operate a facility, a residential facility. We have already dealt with this. We note and appreciated the submission, and it has also been addressed earlier. The other submission relates to the developments for independent older persons run by the residents or owners in the case of sectional titles or shared block schemes or their agents, and that should not be subjected to onerous registration requirements. This issue was raised earlier, and we further have indicated appreciation of this submission, and that we have also addressed it in the earlier slides. There is also a recommendation by the association that it should be made clear that which social workers are allowed to remove an older persons without a social worker to undertake due to the extent and implications of the intervention. In this regard, we indicate that we note the comment and appreciate, and the department is aware of that particular concern, and we saying that only social workers working with older persons have a responsibility to effect the removal without a court order. And therefore, this duty is parametered. It cannot be conducted or executed by any other person. However, it must also be noted that in terms of the Domestic Violence Act as amended, there is a duty placed upon any person who has a knowledge of abuse of an older person to report such abuse to the relevant authorities. And this would, in a way, imply that any social worker with such knowledge needs to immediately inform the relevant social worker to give effect to the removal without a court order. A further submission by the association relates to Section 13, inserting Section 18A. And the submission is that the new proposal granting powers to the DG to close independent schemes, for example, sectional title schemes, are a total overreach and impact on the human rights of individual older persons who bought units in these schemes or who have acquired life rights. These are properties purchased by older persons, and in the case of sectional title, where they have title deeds registered in the deeds office, in terms of share block and right schemes, there are legal contracts governing ownership and use. How can this be taken away? Noted and appreciated, and it was addressed earlier in the presentation. And the organization further submits that the registration and deregistration processes are understandable where government subsidies or 24-hour free care facilities are applicable, but closing of independent living developments is not possible. And we say we note the comment. However, it is the duty of the states to ensure the protection and the upholding of the dignity of our older persons wheresoever they are accommodated. In terms of Section 14, amending Section 25A, the association states for the need for positive inclusion, subsection 3B could have relevant inserted before provincial department in line 1 to correspond with subsection 2A. And we say we note the comment. We, however, submit that the word relevant is irrelevant in this particular context, and as it is not imaginable as to how someone in another province would refer a case of removal to another province. The organization further submits that it is interesting that a social worker in private practice is not included in this section. What is an oversight? In practice, quite a number of older persons is supported by social workers in private practice, and they can be very useful in the circumstances envisaged in this section. We say we note the comment as a department, and we appreciate the submission. However, the definition of a social worker is in the Principal Act, and this definition was not. A further submission relates to the definition of social worker in the 2006 Act number 13, also referring to a social worker employed by a registered welfare organization. As far as we are aware, the previous legislation to register welfare organizations had not been applied for years and may even have been repealed. And reference is hereby made to the National Welfare Act. And the department noted the comment and states that the definition of a social worker in the Principal Act was not gazetted. And although this was not gazetted, the proposal is supported. We stand to be guided by Parliament as to whether we can also amend this administrative in nature. A further submission relates to how are social workers going to be accredited as being in the employ of a registered welfare organization. It cannot just be accepted that a social worker in the employ of a registered nonprofit organization is now also employed by a registered welfare organization. And as a further submission that there's no provision in the Nonprofit Act to accredit nonprofit organizations as welfare organizations, and thus the definition of social worker in the 2006 Act cannot be applied. The department submits that it notes the comment and appreciates the submission. However, the definition of social workers in the Principal Act was not gazetted. And the proposal is therefore supported because we stand to also want to deal with this matter regardless of the fact that it was not gazetted. We also further seek guidance from Parliament as to whether we can also amend this part as it is not substantive, but remains administrative in nature. A further submission relates to the description of the register of non-profit organizations, which is NPOs as a voluntary registration facility, and that this process does not include any verification of services, standards, or controls. This legislation relates to the fundraising aspects and not any accreditation of social work practices. The department has noted the comment. However, this was not gazetted, and it is not clear what the comment really seeks to achieve. In terms of and section 2, what is meant by family care or special care? Who will assess and when is it appropriate? Why highlight disabilities and chronic illnesses in the bill? This can be managed in regulations, charters, policies, or plans. This is also a repeat of what was raised earlier on, and it was also responded to earlier. There's also a submission relating to dignity, well-being, and participation of all older persons, and that they are all important, not only that of persons with disabilities or chronic illnesses. it does not serve a purpose to identify subgroups and label them. And the comment is noted and appreciated. A further submission under section 16, amending section 26, relates to the use of manager, where the association states that is still odd, as there is a definition of manager, which has also been amended in this bill, but this might have another intention. We're saying the comment has been noted and it was also addressed earlier. Also, is it appropriate to allow a manager of a facility with unknown qualifications to investigate suspicion of abuse? What is intended here? Is it just a preliminary investigation prior to reporting to a social worker or a police? The facility manager cannot, in terms of section 25, remove the older person and take the other steps described in section 25. The facility manager, like other professionals, should report under section 25(1). And we say the department has noted the comment. However, it is appropriate for a manager to investigate any suspicion of abuse, as he or she has a duty to report such abuse to the relevant authorities, not only in terms of this legislation, but also in terms of the Domestic Violence Act as amended. It would be impractical for one to report something that they themselves have not investigated. The word investigation in this regard is being used loosely to imply fact-finding, and this does not require a particular qualification to be executed. Now, in terms of section 17, which seeks to the privilege against self-incrimination must be considered and kept in mind. Possibly also the stipulations of the Criminal Procedure Act number 51 of 1977 and the rights a person has in terms of the Constitution. And there is also a concern raised relating to why the language the older person understands and not selects. And in terms of section 18, amending section 30, we are saying the comment is noted and appreciated. However, the term understands, as it relates to this provision, is used correctly, as both words can be used in one sentence. An example, an older person may select a language which she or he understands. This is a useful amendment, and this comes from the association, and we note the comment and appreciate that submission. The organization further submits that section 19, 20, 21, and 22, amending section 31, are understandable. We note the comment and appreciate the submission. We now move to the submissions made by Ilita Labantu. The organization we note the submissions made by Ilita Labantu and others. The organization welcomes the purpose of the bill and its proposed amendments and the insertion of the definitions provisions on monitoring and evaluation, specifically relating to the removal of older persons to a temporary place safe care without a court order, strengthening of implementation and compliance measures. We note and appreciate the comment, and that falls within the general issues. And under section 1, the organization states that it welcomes the insertion of new and improved definitions, which will help to ensure that service provided to older persons meet established standards of quality. It points us that there have been deficiencies in the provision of services to older persons because of limitations in definitions. It particularly welcomes the redefinition of an older person, as this is of the view that It will ensure that older persons will be equally entitled to benefits and protection. And this is because place serious limitations on their access to benefit. And the department notes the comment and appreciates this submission, and also states that the age of 65 for men has long been amended in terms of the Social Assistance Act of 2004 as amended. A further submission relates to Section 2 in terms of objectives. The organization welcomes the recognition and provision for the specific needs and preferences of older persons so that services can be tailored to meet the diverse requirements of South African elderly population. It notes that preventative measures against abuse means there is an effort to ensure that the society that respects the rights and well-being of older persons is fostered. And the department notes the comment and appreciates the submission. In terms of Section 3, relating to implementation, the organization states that it welcomes the contribution that must be made by other government entities, including stakeholders who must be coordinated so as to provide integrated service, thus ensuring accountability. The department noted the comment and appreciated the submission. In terms of Section 4 to 5, which relates to the application and general principle of the legislation, the organization indicates that it welcomes these sections as they establish indicators and benchmarks that make it possible to access the effectiveness and efficiency of the services for older persons. It notes that the identification of harmful traditional practices, including witchcraft accusations, which may refer to welfare, health, life, and dignity of that older person, addresses the shortcoming that has been prevalent in certain communities, insufferable harm to older persons accused of such. So older persons who suffer from dementia are labeled as witches and some are killed. And we have noted the comment and appreciated the submission, as these situations are also being addressed by the department and remain of significant concern to the department as well. In setting Section 7A and 7B, the organization submits that it welcomes the insertion of Section 7A and 7B as it allows for intergenerational dialogue and solidarity within communities and aids in passing traditions and heritage. This shows that the department rights have been violated regarding property and inheritance. So older persons who are illiterate have also been coerced into signing documents that have resulted in them losing their homes or possessions. The comment has been noted and appreciated. Further submission relates to Section 10 to 15. The organization submits that regular monitoring and evaluation provides an opportunity to identify innovative approaches and make adjustments to enhance the effectiveness and efficiency of services aimed at improving the well-being and rights of older persons. And further indicates that organizations need to constantly adapt and respond to the evolving needs of older persons and ensure that their services remediate this. So the comments are noted and appreciated. The organization further recommends that the bill should provide for strengthened penalties for non-compliance and also dealing with offenders, and reporting mechanisms for older persons to report abuse, such as helplines, hotlines, or online reporting platforms should also be made available. The department submits that it should be noted that this bill goes further to provide for the removal of an older person who is being abused without a court order. the department provides for the removal of this older person without a court order. This position is being strengthened by the Domestic Violence Act as amended, which also calls upon any person to report such abuse to the relevant authorities. Now, the National House of Traditional Leaders and various individuals in the provinces have also made some submissions. And the first submission relates to the support of the bill and that they expect it to have a positive impact on the lives of older persons if properly implemented. The department notes the comment and appreciates the submission. A further recommendation is that the bill must also include verbal and emotional abuse. And the department submits that Section 33C of the Principal Act provides for varied forms of abuse, including verbal and emotional abuse. A further submission relates to means test, and where they state that it disqualifies deserving older. The department notes the comment and submits that this falls outside the scope of this bill or the Principal Act. But be that as it may, the relevant functionaries within the department have been advised of this submission, and the matter is currently receiving the necessary attention. There's a recommendation that means test must be removed or changed to have every elderly person to receive social grants irrespective of the financial status of their spouses. A further submission relates to the definition of assisted living facility, where the organization says that it is not clear what is meant by partially independent, and terminology in this manner may result in the term having different interpretation. And the department submits that it notes the comment and appreciates the submission. However, we are of the view that the word partial in the context of partial independence or the word independent carry their own ordinary meaning. It would have been advisable if a proposal could have been sponsored for the definitions of partially independent or total independence in line with the submission by the organization and its partners. The term affordable is vague and may be difficult to measure. This is because within a specific facility, the levels of fees are affordable and others not. The department submits that the term affordable is not part of the gazetted provisions of the bill. It would therefore not be prudent to deal with it, as it would have a potential to disadvantage the broader community who would have had a different view regarding that. Ordinarily, in circumstances like this, affordability would have been viewed from an objective angle, taking into account the personal income of an individual. In terms of the organization's submission relating to insertion of Section 7A, the organization and its partners state that they welcome the insertion and further recommend that traditional leaders and their traditional countries and traditional communities in matters affecting older persons, and further state that traditional courts may also be used to resolve disputes through restorative justice. The department submits that it notes the comment and appreciates the submission. However, Section 7A relates to the responsibilities of older persons towards their families and their communities at large. So it should be noted that there is a separate piece of legislation that deals with the role of traditional leaders and traditional councils, as well as traditional courts, which may provide for such responsibility. including this proposal in this bill would be to extend the scope of the Older Persons Act and encroach in the space that belongs to other organs of state. In terms of the insertion of Section 25A, the organization has submitted a concern about the clause in the bill relating to the removal of an older person without consent from the older person or the court order without sufficient evidence. The organization and the inability of the older person to provide consent, the duly authorized person must be provided with sufficient information to make an informed decision. The right of privacy of an older person and personal information of an older person must be protected. The government submits that it notes the comment. It is, however, not correct, as the bill emphasizes the need for consent before removal can take place, as indicated in the excerpt below. Section 25A, 1, states that a social worker or healthcare provider or a police official must, with the consent of an older person or authorized person, in the event that the older person is incapable of providing such consent, remove such older person and place that older person in temporary safe care without a court order that the older person is being abused. The organization and its partners further submit that there should be a clause in the bill to provide for any person entrusted with the care of older persons to face consequences for improper conduct of care and negligence of care of older persons, and that the state should enforce consequence management to any person who mistreat older persons. And the department submits that it knows the comment and appreciates the submission. And in this regard, the bill does not provide for consequence management by creating penalties in the event of improper conduct and negligence in the care of older persons. And we refer the organization to clause 20 of the bill, which amends section 33 of the Principal Act for further clarity and further information in this regard. Now, there are submissions that came from the Western Cape government, and in terms of the general comments, the Western Cape government raised concerns around the implementation of the services provided for in the bill, as well as the costing of the bill. It further raised a question if the additional costing and its impact on the provinces was adequately considered in the socio-economic impact assessment that the department had conducted. Chair, we submit that the bill was costed and its impact on the various provinces was adequately considered through the socio-economic assessment exercise that was conducted by the department. And this is clearly articulated in the said report. We, however, remain mindful of the fact that much time has lapsed between the time that the bill was posted and the time that it is being processed. And it was mainly due to several other consultative sessions and as well as approval processes. Now, the costing methodology took into consideration the inflation rate at the time when the bill was asked to also, take into consideration the inflation at the time when we will be starting to implement. So such projections will then happen at the time when implementation commences. The Western Cape government has also indicated that it has no fiscal room to reprioritize further without harming other critical provincial services, and that the national funding strategy should look at norms and standards across the sector as a whole to reduce the cost of non-essential mandatory social development services for provinces. And we note the comment. However, with reference to services for older persons, they remain essential and mandatory services for the department. The Western Cape government further submits a recommendation that the implementation of all the proposals in the bill must be subject to formal costing, and adequate additional resources must be provided to the provincial departments to perform these functions, and that the Financial and Fiscal Commission should also be consulted given the intergovernmental fiscal impacts of the amendment bill. And the department submits that it knows the recommendations and shall be escalated to the relevant authorities. A further submission by the Western Cape is that it seeks clarity on caregivers, and that more clarity should be provided in the bill as to the roles and responsibilities of persons who do not fall within the current proposals for the definition of caregiver. For example, a person who is not accredited as a caregiver volunteers to serve or care for an older person by agreement between them, where home-based care is not applicable. Would such person fall foul of the intended legislation for not having the necessary qualifications? A further submission is that what about the family members who do not reside with the older person but render care to the older person within the meaning of the term care as defined? If the scope of the definition of caregiver is too restrictive and only acknowledging those persons with accredited qualifications to be caregivers, could this mean that any other person providing care, even within the consent of the older persons, would be acting unlawfully? The comment is noted by the department, and it has also received attention, and it has been addressed within the matrix. This slide is a repeat of the slide that I have just responded to, which talks to the clarity on caregivers. The next slide brings us to the recommendation by the Western Cape government with regard to the bill, where it states that the bill needs to provide better guidance as to the roles, the status, and responsibilities of persons in general, not only caregivers as defined, who provide care to older persons. And the department has noted this comment, and this comment and related submission have also been unpacked and further addressed in the matrix. In terms of section 1, relating to the submission by the Western Cape government, clause 1, the words used for the provisioning of safe and accessible accommodation to older people needs consideration. And the government of the Western Cape further indicates that there's need to compare with the wording in the definition of assisted living facility described as a residential facility used for the provision of safe and accessible accommodation. And the word provisioning is more conducive to the provision of food or money and not accommodation. The department has noted the comment, and this matter has been addressed in the matrix. A further submission is that the wording in the definition applicable to the different kinds of residential facilities be aligned for purposes of consistency, and that the word provisioning not be used in this context. The comment is noted, and it has been addressed in the matrix. There is a further submission relating to definition of interdepartmental structure, where the government of the Western Cape says that there's need to correct the term South African Police Services to South African Police Service in keeping with the provisions of the South African Police Service Act, number 68 of 1995. And the department has noted the comment and appreciates the submission, which has been addressed in the matrix. A further submission relates to clause 3, in terms of the insertion of subsection 5. The organization submits that the Western Cape government's concerns centered around the costing of the additional responsibilities of the proposed coordination between the Office of the Premier and the Provincial Departments of Social Development regarding the coordination of provincial plans and the implementation of this act as may be prescribed. The latter proposal suggests that there may be regulations in the pipeline to this effect. These additional responsibilities necessitate additional capacity and resources. Given current fiscal constraints, the Provincial Department of Social Development in the Western Cape does not have the financial resources to implement these additional functions and mandates. And the department has noted the comment, and it has also been addressed earlier in the presentation. Now, a further recommendation is that the implementation of all the proposals in the bill must be subject to formal costing and adequate additional resources. This is a repeat of what was mentioned earlier on. And the department has noted and the submission and has dealt with it in the earlier slides as I've indicated. In terms of clause 5, there is a recommendation that suggests that subsection 4 must be added as a section to chapter 5 entitled Protection of Older Persons. The word practices should be practices since it is a verb. The comment has been noted by the department and the submission is appreciated. The phrase harmful traditional practices should be defined. Proposal is supported by the department. However, instead of defining, we have rephrased the clause for ease of understanding. A further submission states that specificity is required as to the meaning of taking all the measures necessary to eliminate harmful traditional practices. And the department submits that elimination carries its own ordinary meaning and should be construed in that context. A further submission relates to clause 6, which speaks to the responsibility of older persons. It states that further suggestion relating to the content of this proposed section be included as subsections G, H, and I under section 7 entitled Rights of Older Persons as follows. Under section 7, Rights of older persons enjoy the rights contemplated in section 9 of the Constitution of the Republic of South Africa, and in particular may not be unfairly denied the right to. And in terms of subsection F, access opportunities that promote his or her optimal level of social, physical, mental, and emotional well-being. And G, mentor and pass on knowledge and experience to younger persons. In terms of H, foster and facilitate intergenerational dialogue and solidarity within his or her family or community, and play a role in mediation and conflict resolution in terms of I. Alternatively, current subsections under section 7 can be enhanced to include the content of subsections G to I, where there is overlapping content. And the department submits that the comments are noted. However, the proposal is not supported because the list contemplated in section 7 of the Principal Act is more on compliance issues with section 9 of the Constitution. And it should therefore be noted that the suggested clauses fall outside the scope of section 9. Hence, a new section is being proposed in the bill to deal with issues relating to access to opportunities, mentoring, and passing on of knowledge to the younger generations. Further insertion relates to sections 7A and 7B, with a recommendation that states that if the proposals to the intended section 7A are incorporated, the intended section 7B should then be renumbered as section 7A. And that since the content of 7B deals with the rights of older persons, the reference to physical abuse in the heading should refer to the right to bodily integrity, referred to in section 12(2)(b) of the Constitution of the Republic of South Africa. And that there should be rewording of the heading as follows: for the integrity of older persons. And the department has noted the comment and appreciates the submission and has addressed this matter in the matrix. A further submission relates to clause 9, where there is reference to the additional training provisions of caregivers as contemplated in the proposals to section 14.1. Sorry. Where it relates to the provision of caregivers as contemplated in the proposals to section 14.1, which requires additional capacity and resources. And given the current fiscal constraints, the Department of Social Development in the Western Cape does not have the financial resources to implement. So the department submits that it notes the comment and appreciates the submission, but this matter has also been addressed earlier on in the presentation. And a further recommendation also relates to the implementation of the proposals in the bill and also speaks to the issues of additional resources, which has also been addressed earlier on. And in terms of clause 12, the government of the Western Cape states that the inclusion of additional entities for registration, which refers to private residential facilities, assisted living facilities, or similar facilities, extends the scope of the registration of facilities, thereby increasing the need to capacity and resources. Given the current fiscal constraints, the Department of Social Development in the Western Cape does not have the fiscal resources to implement. This is a resubmission, and it has also been addressed earlier on in the presentation, including the following recommendation, which speaks to the lack of adequate resources for implementation. In terms of clause 13, further recommendation speaks to the correction of the reference to the police, to a police official, since this is a defined term in the Act, or the South African Police. And the department appreciates and have noted the comment, but the department, however, submits that the use of the word police in clause 13.2 has been used in the correct context because reference is being made to the police as a constituted body. And now, in terms of clause 15, there's a submission that relates to a higher level of longevity than in the rest of the country, and thus faces even greater demand for placements at such facilities. Given the current fiscal constraints, the Provincial Department of Social Development in the Western Cape does not have the financial resources to implement these additional functions and mandates. And the department has noted the submission and the comment, and it has been addressed in the earlier presentation. And it is important for the Portfolio Committee to be reminded that the Western Cape, in fact, has a very high number of older persons. So its readiness to respond to their needs remains quite important. There is a further recommendation that the implementation of this clause in the bill must be subject to formal costing. Adequate additional resources must be provided to provincial departments to ensure temporary safe care placement. And we note in the comment, and it has already also been addressed earlier on. There's a further submission relating to liability for temporary safe care, which is contemplated as a shelter or any other place. And the word shelter is defined in the Act as any building, action, and temporary care of an older person in need of care and protection. And any other place has a broad meaning. It could include the residential facilities referred to in the Act or the bill. It could also include other private or public facilities. This again leads to the question as to what is to happen in the event of costs to accommodate an older person in need of temporary care. The bill needs to identify the persons or authority responsible for cost of temporary safe care for a period not exceeding 6 months. And the word any other place do not have a broad meaning because a shelter is defined, which means that any other place would refer to a facility that has characteristics of a shelter. So that's the submission of the department. And we also further submit that the person responsible for paying under normal circumstances shall bear the costs in the case of temporary safe care placement. And ordinarily residential facilities have safe beds, which are fully funded. A further a recommendation from the Western Cape government is that clarity should be provided in the bill as to the liability of the state for payment of temporary accommodation for older persons for a period not exceeding 6 months. And the comment is noted and appreciated by the department, and it has also been addressed earlier on. And in terms of proposed section 25A6, the Western Cape government submits that the misuse of power by a social worker constitute misconduct as contemplated in section 27(1)(b) of the Social Service Professions Act, number 78, Act number 110 of 1978. Now, section 27(1)(b) of the Act empowers the minister to make rules relating to the acts or omissions of, amongst others, persons, social workers, which shall constitute unprofessional or improper conduct. There are a number of sets of regulations made under this Act. The correct set of regulations and the relevant provisions in those regulations must be identified for purposes of this insertion. And the department has noted and appreciated the submission. However, it remains unclear as to what is meant by the correct set of regulations, as there is only one set of regulations for Older Persons Act under notice number 33075, published in April 2010 on the 1st. There's an additional recommendation from the Western Cape government, which recommends that a correction be made to reference to section 27(1)(b) of the Social Service Professions Act. And the comment is noted and appreciated and has been addressed in the matrix. Clause 16, reference has been made to the fact that the prescribed turnaround time as contemplated requires additional capacity and financial resources. This matter has been noted by the department, and it has also been addressed earlier on in the presentation. The issue of resource mobilization as contemplated in this clause must be subject to formal costing and the provision of additional adequate resources. It has also been referenced to earlier on, and the department has also responded earlier on in the presentation. A further recommendation is that the implementation of this clause in the bill must be subject to formal costing, and this matter is also being addressed earlier on in the presentation. And in terms of clause 17, the reference to section 319 Act of 1995, Act number 56, does not appear to be correct. The proposed amendment contemplates a charge, but this provision of the Criminal Procedure Act of 1955 refers to reservation of a question of law. A further recommendation is that there's need for correction of reference to section 3193 of the Criminal Procedure Act, which is a repeat of what I've just said. And the department indicates that the submission has been noted and appreciated, although the Criminal Procedure Act number 56 of 1955 was repealed by the Criminal Procedure Act number 51 of 1977, sections 319, subsection 3 and 384 were not repealed, and therefore reference to this section 319 in the bill remains correct. In terms of clause 18, the definition of physical abuse can be expanded. Physical abuse can constitute an act or threat of violence as stated, but also an omission which results in physical harm. The list of actions after the word including would make better sense if the definition were expanded to include omissions as suggested. And the comment is noted and appreciated. However, the word neglect in the definition is meant to cover for omissions. With regard to medical sedation or shaking, the Western Cape government indicates that the administering of any other kind of medicine, not just medicine which causes sedation or substance or drug without the consent of an older person and contrary to the old abuse. And he's saying the comment is noted, and it will also be unpacked further when the regulations are being developed. There's an additional recommendation that has been submitted relating to the need for further considerations to be given to the definition of physical abuse. The comment is noted and appreciated, and it has also been addressed earlier on in the presentation, and in the matrix it is included. Now, coming to the submissions by COSATU. COSATU has indicated its support for the bill and perceives it as a long overdue intervention to ensure the protection, security, care, and dignity of the elderly. It acknowledges that the bill also ensures that those entrusted with their care are held accountable. The department noted the comment and appreciates the submission. COSATU also supports the bill, specifically those that provide for the following: the right to comfort, ensuring that older person's retirement is one of dignity, is to ensure that their right to comfort is recognized. The department has noted the comment and appreciates the submission. In terms of facilities, COSATU states that it supports the powers provided to the state to register, suspend, and close any facilities that fail to comply with their obligations under the Act at any time, and additionally supports the enforcement of monitoring and evaluation of community-based care to be always held accountable. And the department notes and appreciates this that they support the registration of caregivers to make sure that only those who are competent are allowed to render services to older persons. And with regard to stakeholders, COSATU supports the amendment of Section 3B of the bill as it recognizes stakeholders, including society, that plays a role in caring for and providing services for older persons. And the department notes the two comments relating to caregivers and stakeholders and appreciates their submissions. With regard to the insertion of Section 7A and B, COSATU supports the fact that community members will have authority to report elderly abuse to the relevant authorities, and many elderly are subject to serious abuse by family members, estate agents, and others who seek to exploit their vulnerabilities and access their inheritances. And provincial governments play a significant role in terms of services for older persons. COSATU indicated that this important stakeholder has neglected investments in what is a rapidly growing need for society and culture evolve and change. The department has noted the comment and appreciates the submission. COSATU has also indicated that it welcomes the proposed amendment which requires educational support and special care for the elderly with regard to NCDs and chronic diseases. The elderly are at extremely high risk of infection and chronic diseases increase with age. The comment is noted by the department. And in terms of temporary safe care, COSATU submits that it supports the provisions of temporary safe care for the elderly who have been victims of abuse to be removed from dangerous environments. The department has noted the comment and appreciates the submission. COSATU welcomes the proposed extended definition of physical abuse. The department notes the submission and appreciates the comment. In terms of submissions made by Dear South Africa and partners, 168 individuals made submissions, 163 did not support. They did not support because they were opposed to the removal of an older person without permission. They argue that older people have as much right to voice their opinions and are a very important part of society. They are still able to think and do things for themselves. Therefore, the bill is an infringement to the rights of older persons. The department's submission is appreciated, but it should be noted that the bill is intended to protect the rights and uphold the dignity and integrity of older persons as contemplated in Section 10 of the Constitution of the Republic of South Africa. And 2 organizations or individuals did not indicate their position, and 5 has supported. And in this regard, the department notes the comments made by Fourie and others from Dear South Africa. Now, coming to the submissions by Mr. Johan Rodemeyer, there's a submission relating to abdication of responsibilities, which speaks to concerns about government's abdication of its responsibilities towards older persons and shifting such responsibilities more and more towards them. At the same time, it imposes more and more legal requirements to service providers to qualify for basic grants. The department has noted the comment earlier and also responded to a similar comment. Now, there's a further submission relating to municipal bylaws, where Mr. Johan Rodemeyer submits that municipality imposes stringent bylaws that require millions of rands to be spent to make buildings compliant, and that such expenditure impacts on the already limited budgets of the centers, resulting in them cutting back on quality of services and reducing staff numbers. And the department notes the comment, and it was also noted earlier, and it was addressed earlier in the presentation. There is a further recommendation by Mr. Rodemeyer, who states that government should pay for the implementation of bylaws or the levels of the bylaws be lowered to manageable standards. And the department submits that the comment is noted and it was addressed earlier. And in terms of training of caregivers, the proposed amendment imposes yet more requirements that must be implemented by the private sector to comply in providing statutory services. And the department submits that it notes the comment. However, the training of caregivers is really intended at ensuring that those people that provide care to older persons have the necessary competencies to execute such responsibilities. And in terms of the removal of older persons to temporary safe care, Mr. Rodemeyer wants to know where these facilities are located. And he argues that this is another pipe dream of government, which the private sector has to come up with a solution and pay for. And the comment is noted by the department, and it has been addressed earlier on in the presentation. There's a further submission relating to funding of service centers for older persons, where Mr. Rodemeyer indicates that persons but their funding has been kept at 160 members, making it financially impossible to roll out services. This issue has also been addressed earlier on in the presentation, where the issues of funding were articulated. Now, there are other submissions that came from the Catholics Parliamentary Liaison Office. The Catholics Parliamentary Liaison Office indicates that it welcomes the insertions of definitions, particularly those relating to the monitoring and evaluation of all services to older persons. The department notes the comment and appreciates the submission. And further submission is that the extended definition of rehabilitation is welcome, and that this proposal, there's a wide range of physical and occupational therapies which can do much to enrich the lives of the older persons. And the comment is noted and welcomed by the department. And a further submission relates to the definition of care. The inclusion of spiritual care resonates with the Catholic Church. The recognition of the importance of the spiritual dimension in the care and comfort of older persons is a holistic and comforting approach. The comment is noted and the submission is appreciated. A further recommendation by the Catholic Parliamentary Liaison Office and support, and that support groups to families and those with particular conditions such as Alzheimer's should also be encouraged and facilitated. The comment is noted and appreciated, and it has also been touched on earlier on in the presentation. Now, on the issue of removal of older persons to temporary safe care, it submits that it should be done in the best interest of the individual, which is also noted by the department. A further submission and is that this matter has also been addressed in the bill. And then there is a submission from the organization which talks to access to health, older persons, especially those with impaired mobility, chronic health conditions, and advancing frailty, particularly those in rural areas have difficulty accessing primary health care. CPLO cites findings of the South African Human Rights Commission, which noted that older persons, particularly those who are adversely impacted when they try to access health care. The comment is noted and appreciated, and it has also been touched on earlier on in the presentation. The Catholic Parliamentary Liaison Office further talks to the issues of witchcraft accusations. It states that it welcomes the attention given to witchcraft in the bill, as witchcraft is related to the domestic violence and continues to plague in rural areas, predominantly targeting elderly women. And this is prevalent in Limpopo, Mpumalanga, the Eastern Cape, and KwaZulu-Natal. And the department notes the comment and appreciates the fact that there should be more education of the public about Alzheimer's disease and dementia by DSD and the Department of Health to promote greater understanding of the effects of old age, and that education also include the necessary measures to eliminate harmful traditional practices, including witchcraft accusations which affect the welfare, health, life, and dignity of older persons. The department has noted the comment and appreciates the submission, and this matter has been addressed in section 7(2)(c) of the Principal Act and in the bill. A further submission relates to the register of abuse of older persons. The organization submits that the incidence of older person abuse in South Africa is not clear and that elder abuse generally does not result forms of interpersonal violence in the broad context of global aging, and that little is known about the experiences of abused older persons, and that often cases of older persons are not registered, and where, when reported to the police, such cases are classified under general or indecent assault or murder. And the department has noted the comments and the related submissions and has addressed this matter in clause 18B of the bill. A further submission relates to the Children's Act and the Sexual Offences Act, making provision for similar registries as the Register of Abuse of Older Persons. It argues that these registries are to be part of the protective strategies to protect the vulnerable. Measures must be put in place to ensure their success. Thus far, however, the existing registers have met with little success and have been poorly maintained. During public hearings regarding both the Children's Act and the Sexual Offences Act, it was suggested that such offences should be included in the criminal record, as this is the only record that is regularly maintained and updated. The department knows this submission, and it has been addressed in section 31(1) of the Principal Act. Now, coming to the submission that was made by Timeless Care for Seniors, the organization suggests that safe homes strictly for elderly should be implemented in the bill. The recommendation is that our elderly should be enjoying their last few years with dignity, peace, and love, and that we as an organization believe that our elderly is our hero, and let us be part of those senior citizens, our mothers, our fathers of the nation. Let us be part of the change, as we do not know what the future holds for each one of us. Together we can build a fulfilled senior community. The department notes the comment and the related submission. And that brings me to the end of the submissions that were made by organizations and partners. We now move to the final part of the presentation, which will articulate the consolidated provincial public hearing inputs. The first slide covers comments, recommendations, and proposals and clause. Now, coming to the nature of the bill was supported because its amendments show older persons have been neglected for comment, and that has given the youth misconceived power to abuse older persons. The department noted the comment and supported as it was received in line with the bill. The bill gives older persons the right to speak for themselves. It also uplifts and gives older persons dignity. The department notes the comment and appreciate the support received on the bill, which will uphold and protect the dignity of older persons. The recommendation that follows is that there should be a widespread education across all levels of government on the bill once it has been passed into law. The department notes the comment and appreciates the submission, and the comment has been addressed in the bill and in the matrix. The importance of training, capacity building, and awareness campaigns prioritized and conducted during implementation phase. In terms of definitions, most speakers supported the submission for the definitions of older persons in the Principal Act, which the bill proposes that an older person means a person who is 60 years of age or older. The amendment was supported because it will also do away with the discrimination against older men regarding access to government benefits such as the old age pension. The amendment thus ensures equal rights for for both men and women. And unequal ages used to create conflicts, specifically leading to gender-based violence and femicide in families. And it was uncultured, as it is commonly known that male persons should provide for their families. The amendment will bring back male dignity in their families as well. So the department has noted the contributed. In terms of clause 3, the amendment of section 3B of the bill was widely supported by the speakers, as it recognizes stakeholders in the provision of services to older persons. However, it is proposed that the bill should clearly outline the responsibilities of all stakeholders in order to ensure adequate services for older persons. The department has noted the comment and appreciated and has addressed, and this has been addressed in the bill and the matrix, the roles and responsibilities of organs of state and all other key stakeholders will be outlined in the regulations to ensure the strengthening of the importance of collaborative approaches, joint planning, resourcing, as well as integrated approaches to service delivery. A further submission was that about the poor services they receive at healthcare facilities, specifically the local clinics and hospitals, the police stations, the banks and municipalities. They stated that they stand in very long queues with no shelter, chairs, access to water and ablution facilities, and that healthcare facilities often have shortage of medication, and that police officials do not investigate reported cases of elder abuse, and that municipality bills are not affordable to all older persons. And the department has noted the comment and appreciated the submission. However, the issues relating to other organs of state will be addressed through other platforms such as bilateral meetings and workshops. The department will also respond to presentations made by the organs of state that appeared before the Portfolio Committee on Social Development to respond to issues raised relating to the matters. In terms of elder care, there was a comment relating to that, which spoke to the involvement of responsibilities of various government departments and institutions of government that seem to operate as separate entities, such as the Master's Office. And there was an indication that elder care falls under the Department of Justice and Constitutional Development. And the comment is noted and appreciated, and it has been further unpacked and clarified in the matrix that has been provided. And there is also a recommendation that these facilities to have separate dedicated queues specifically dedicated for older persons. And the proposal for dedicated separate queues for older persons is accepted and will also be included in the regulations to ensure that these issues receive attention as they were raised across various provinces at different platforms where the public hearings were held. Now coming to clause 4 and 5, the insertion of clauses 4 and 5 of the bill is welcome as it mandates all organs of state and all officials to respect, protect, and promote the rights of older persons. Most speakers propose that the bill should explicitly include the roles of the departments such as health, human settlements, and local government in bringing services to old age service centers. Also, the inclusion of youth as ambassadors of older persons' rights was highly recommended. The comment is noted and appreciated and has been addressed in the bill and in the matrix. The roles and responsibilities of all organs of state, including the key stakeholders, will be outlined in the regulations by the department, having noted this critical comment. And an additional comment is that only DSD visits older persons services centers to conduct monitoring and provide services. So the Department of Health is alleged not to be visible, hence there is a shortage of healthcare services. The department has noted the comment and it has addressed this matter in the matrix. And the roles and responsibilities of the Department of Health in the regulations will include, amongst others, joint monitoring of services with the Department of Social Development. An additional comment relates to some residential facilities taking a large portion from old age grants of the residents, and some residents being left only with 200 rand from their grants after this deduction. And this leaves older persons with no money to buy their personal items such as snacks, toiletries, etc. And the department indicates that it has noted and appreciated the submission, and this matter has received attention in the matrix. And the issue of standardization of subsidy across provinces, including how much can be taken from older persons' grant, will also be included and further unpacked in the regulations. Coming to the recommendation relating to traditional leaders, councillors, and the youth, it is stated that this should be provided with the necessary skill and information in order to understand the health challenges faced by older persons, such as dementia and Alzheimer's, and that older persons who suffer from these diseases are often accused of practicing witchcraft. And the department notes the comments and has addressed this comment in the matrix, and further states that there's need for training, capacity building, and awareness campaigns to be conducted across the sector with all critical stakeholders addressing all critical issues. And this will also be further unpacked and included in the regulations, and will be conducted during the implementation period. That is the continued or ongoing capacity building and training of our key stakeholders. In terms of clause 6, the insertions of section 7A and 7B, the insertion of section 7A and 7B was most welcome and supported as it promotes mentoring and passing of knowledge and experience to the younger person, while 7B protects older persons from any form of violence, sexual abuse, and discrimination based on gender, etc. Clause 7B of the abuse related to the right of inheritance will resources when an older person passes away and the grandchildren misuses of her money. The department has noted the comments and appreciated the submission and have addressed this matter in the bill. Properties of older persons are transferred to grandchildren without their knowledge. These older persons end up being homeless. The comment is noted by the department, and it has also been responded to by the Department of Human Settlements, and the department will also continue to collaborate with the Department of Human Settlements to ensure that the issue is progressively addressed, noting the reports that have been received in this regard. A further recommendation relates to government, the need for government to employ retired educators to organize other older persons and facilitate workshops for older persons. And the department has noted the comment and appreciates the submission. However, the department cautions that employing retired educators will require additional funds, and due to high fiscal constraints and high youth unemployment, government will not be able to afford this service, and allowing older persons to work as much as they are still healthy and mentally fit should also be considered based on a need of the various organs of state and on the availability of funds. The further submission relates to comment on the Department of Rural Development and Human Settlements that prior to change of ownership from the previous owner, and especially if the house belongs to an older person, and that there should be a process to verify the legitimacy of the transfer of properties of older persons to their children or grandchildren. And the department indicates that it's noting the comment and appreciates the submission, and it has been addressed in the metrics. The recommendation regarding the verification of ownership will also be discussed with the Department of Human Settlements and will be included in the regulations as part of the roles and responsibilities of the Department of Human Settlements. In terms of clause 7, there are recommendations to that effect that the Department of Health should train and educate communities, families, police, elderly people, and caregivers on dementia and Alzheimer's disease, so as to stop violence against older persons who have dementia. Policy, and that there should be training programs where older people can be trained on how to use technology, ATMs, smartphones, and computers. The department notes and welcomes the submissions, and there has been a further unpacking of this, and it has been addressed fully in the metrics, and the information sharing, awareness, education, and different training relevant to older persons by the organs of state and key stakeholders will also be considered for inclusion in the regulations as they get to be crafted. And additional comments relate to an older person who also need to be taught sign language, and that older persons must also be taught to read and write. And a request was also made that adult basic education and training should be reintroduced at residential care facilities. And the comments have been noted and appreciated and have been addressed in the metrics. The information sharing, awareness, education, and different trainings relevant for older persons by the organs of state and key stakeholders will also be included in the regulations. And that there's a further submission that government should have proactive measures that will ensure that services to older persons are provided even when there are any pandemics or unforeseen natural disasters. So the department noted the comment and appreciates this. This proposal will be addressed in the regulations because we also noted the serious challenges that were confronting older persons during the period of disasters as well as during the period of COVID. Hence, we feel it's important that even though we are going to consider this in the regulations, there should be guidelines that are going to assist to guide our stakeholders in terms of responding to our older persons during such periods. The bill should also include financial education of older persons. The comment is noted and appreciated and has been addressed in the metrics, and the information sharing, awareness, and education and different trainings relevant to older persons by the organs of state and key stakeholders will also be included in the upcoming regulations as we get ready for implementation. And now coming to clause 8, most speakers across provinces did not fully support the proposed amendment. They raised the following concerns. Proposed amendment to Principal Act Section 13 by substituting the word stop for the words terminate or suspend. By suspension can either be permanent, which is synonymous with termination, or temporary. The department has noted the comment and it has addressed this matter in the metrics, but to avoid confusion, the duration of the suspension and the conditions which determine the duration of the suspension will have to be specified as we develop the regulations. And the other submission relates to centers and clubs who want to register and operate within the law, but requirements are not user-friendly, and officials who are supposed to be assisting also take long to respond, and when they do, they only point shortcomings. In this regard, the department has noted the comment and has indicated that for facilities and centers to register services, it requires joint assessment and evaluation by different organs of state, such as municipalities, DOH and DSD. Bilateral meetings will be held with the relevant organs of state to fast-track the registration process. Joint assessments, monitoring and evaluation with municipalities, COGTA and DOH will be included in the roles and responsibilities of these organs of state. Now coming to clause 8, there are NPOs that are operating from municipal-owned buildings who are struggling to obtain lease agreements from the municipality, which are required for registration purposes. And the comment is noted by the department. However, this falls outside the mandate of the department and will be addressed with the relevant organ of state. Joint assessments and monitoring with municipalities will also be included in the roles and responsibilities of COGTA. And further comments, the majority of older persons explained that because they do not meet norms and standards, they meet in open spaces under the trees, and some centers operate with dilapidated structures or mud houses, and the centers do not have ablution facilities, windows, and doors, and are not fenced and do not have access to water supply. The department has noted the comment and states that for facilities and centers to register services, it requires joint assessment and evaluation by different organs of states such as municipalities. The Department of Health and the Department of Social Development are also part of the team that needs to perform the assessment and evaluations. And there's also the relevant organs of state to fast-track the registration process, and joint assessments and monitoring and evaluation are done with municipalities, and COGTA and DOH will also be included in the roles and responsibilities of these organs of state. And a further recommendation relates to private residential facility needs to be defined succinctly from personal private residence. Clause 8, section 13(1)(a) should have same penalties as clause 20, section 33 in terms of liable fine or imprisonment. The comment is noted and appreciated. The definition of private residential facility has been addressed in the matrix, and the comment is noted and appreciated and has been included as I indicated in the matrix. So the additional comment relates to the bill that it should allow any person who is suitably qualified to care for an older person. And the department notes the comment. However, the department does not support this comment. The issue of natural and versus juristic persons has already been addressed earlier, and I am not going to belabor the points in this regard. There's a further comment relating to the bill and its need to provide definition of private residential facility to ensure that section 13 clause 8 does not include family members in their own private residences caring for older persons. And the response by DSD is that the comment is noted and appreciated and has been addressed earlier in the slides, and that family members are not excluded as caregivers, as this refers to any person who provides care for an older person. Now, a further comment relates to registration or revoking of the facilities, which should only be done for those care centers endangering the lives of older persons. And DSD submits that the comment is noted. However, the proposal is not supported. The proposal is not supported because registration or revoking of facilities is dependent upon various factors, and key amongst others, that will include compliance to norms and standards by a particular organization. And before closure can be effected, support is given to facilities to ensure that there are engagements and the space for improvement granted, and that there is progress reported and monitoring of those improvement agreement areas of improvement agreements there to are also, you know, monitored. So before such a decision relating to closure can be effected, there is enough support that is granted to facilities. So the closure is only done when it infringes on the rights of older persons and aimed at protecting the safety, security, and dignity of older persons, which is the central focus of this bill. So if there are any reasons for the department to conclude that older persons' rights are infringed upon and they are not protected or they are not safe or their security and dignity are at stake, then such facilities will then be considered for closure. A further comment is that the bill should set standard tools which relate to and distinguish service centers according to rural, informal, and urban areas. And you say, you know, the comment as a department, and it will be addressed in the regulations and within the norms and standards. Further submission relates to the bill that it should clearly stipulate requirements for temporary registration of community-based care and support services. The department states that the comment is noted and appreciated and has been addressed in the Principal Act and the regulations. There's a further comment relating to the insertion of duration of suspension or deregistration of the care center, and that it should provide conditions which determine the suspension. And the comment is noted by the department and will be addressed in the regulations. In terms of clause 9, there's a submission that there was an overwhelming support on the insertion of prescribed training, including the bill. However, the caregivers advocate for accredited training. The comment is noted being included in the Principal Act. Regulations and the bill, as well as the regulations and the bill. And this will be revised in the regulations to address some of the concerns that have been raised. And a further comment relates to all trained caregivers for older persons care centers who must be taught standardized curricula through prescribed training. And the department knows the comment and is already included in the Principal Act, the regulations, and the bill. And the department has already prescribed the training in the regulations and has developed a caregiver manual, which has been accredited with the Health and Welfare SETA as 3 skills program, which focuses on the rights of older persons, including elder abuse, Alzheimer's disease, and palliative care. So in terms of training of caregivers, there's a further submission that it should be a priority. And the department knows no training of caregivers. A further submission is that there is no training of caregivers, especially on frail care. There is also no funding for frail care. Resources such as diapers and transport, allocated funds are only for food. And the department knows the comment, and that has been also addressed in the earlier slides. And there is a submission relating to elderly people also being considered as caregivers. Some of the young people do not know how to take good care of older people, and hence the comment. And the department knows the comment, and there were no comments where older persons were pleading for support from younger generations. And the proposal will be considered by organizations depending on how active and healthy the older person is, as caregiving is a strenuous job which requires an active and a healthy person who will be able to walk across the communities from moving from one house of an older person to another and effectively providing the necessary support and care. Now, approximately, another comment relates to the approximately 80% of caregivers who do not receive anything. Even though the government started providing training, it was last done in 2018. So any person who provides home-based care must ensure that home-based carers must have proper training. The department has noted the comments, and this has been addressed in the bill and as well as in the earlier slides where we are covering issues of caregivers. And in support of the amendment, some speakers sought clarity on where caregivers can obtain the prescribed training. They also wanted to know how will the caregivers be trained and what are the consequences if a caregiver is not trained, and who will they be accountable to for their services? How will their referral pathways be done? So the department has noted the submission and the related comment, and the department does offer the prescribed training at national level. However, due to budget constraints, the department has embarked on a process to conduct the trainer workshops across provinces to train accredited service providers in provinces to ensure that provinces are able to train at provincial levels using provincial accredited service providers. And caregivers who are trained will be registered on a database for proper monitoring. For those who are not trained, provinces will develop implementation plans on how they will ensure that the caregivers are trained in a phased-in approach, as they will budget for this cost due to financial constraints at national level. All provinces will also have to have provincial databases of all caregivers, including those that are already trained for accountability purposes, because these people work across the sector and there is need for them to be held accountable in terms of the quality of services that they provide to the older persons. And there was also overwhelming support for the proposed amendment, which is clause 10. Then the following inputs were made: monitoring of the older persons community-based care centers, which minimize maladministration. There is also a need to strengthen. Is also another submission relating to monitoring of care centers, that there should be older persons driven, and that social workers monitoring at the community care centers should consider engagements with older persons. And the department submits that they've noted the comment, and the monitoring of community-based care is included in the Principal Act, and as well as the bill and the metrics. So additionally, most of the comments relating to the monitoring of facilities have been addressed in the earlier slides, and the department will outline clear guidelines in the regulations. And there's a recommendation that there should be constant monitoring and evaluation of the older persons through announced and unannounced visits by the designated official to determine whether the well-being of the elderly people in community-based care centers and support service centers and at home-based care centers is that it has noted the submission, and it will be addressed within the regulations, as that will also include residential care facilities and not only the ones that are based within the communities. The proposed amendment was supported in terms of clause 12, but there were some concerns that were raised. The process for the registration of residential care facilities are onerous, and service centers end up being operated in old buildings or community walls. The department has noted the comments, and with regard to the issues of the registration process, these have been addressed earlier in the slides, and there is a commitment to ensure clear guidelines that will be included in the regulations and the norms and standards for consideration by all key stakeholders and service providers. and those that are operating from rented private properties in makeshift structures, and that they do not have the necessary facilities and gym equipment, and government was requested to assist these centers to be allocated land by municipalities and provide funding to build permanent structures. The comments are noted and appreciated by the department since NPOs operate independently, and the issues of gym facilities, equipment, and land requires engagement between various organs of state, as some fall outside the mandate of the Department of Social Development. Further comments relate to that there are many people who take care of their elderly, people in their private homes. The bill should make provisions for this kind of service, and that it is costly for NPOs to obtain certificates such as zoning, health, and food acceptability. It was also requested that these NPOs should be partially exempted. And with regard to the many people who take care of their elderly people in their private homes, the comment has been noted by the department, and it has been addressed in the metrics and in the earlier slides. And with regard to the costliness of NPOs obtaining certificates for zoning purposes, the comment is noted and appreciated. However, certificates outlined fall outside the mandate of the Department of Social Development, and it should be noted that municipal bylaws are there to protect our citizens, which include our older persons, upheld at all times and protected by ensuring that organizations are compliant with all the relevant legislative prescripts and policies. And in terms of clause 13, there is a submission that in support of the proposed amendment, the speakers have made submissions relating to the closure or deregistration of facilities, and that it should be for facilities endangering the lives of older persons. And the department has accepted the comment and appreciates the submission, and it has been further unpacked and addressed in the earlier slides and in the metrics as well. And then with regard to clause 18A, there's a submission that it should be included in the penalties in section 33 as an offense, as it deals with instances where a facility is deregistered or closed. The comment is noted and appreciated by the department, and it has been addressed in the metrics. A further comment relates to the bill being amended, and that the proposed 30 days of deregistration of a residential or community-based facility for 90 days. And the comment from the department is that it has noted this proposal and it has addressed this in the metrics. And the proposal to amend 30 days to 90 days is not supported. And the reason is that 30 days is mainly proposed to ensure that we afford the community-based care and support service centers and the residential facilities that opportunity to make sure that they represent, they have space for the representation of before their deregistration happens. So it is specifically just for that reason. So expanding it to 90 days really will create unnecessary problems. Now, coming to the further comments submitted, it relates to the monitoring and evaluation as well as the training conducted before the facility is deregistered. The comment is noted and appreciated and has been addressed in the Principal Act and the regulations, and it has also received attention now in the metrics. And a further comment relates to the juristic person who should be assisted, trained, and given an opportunity to make the facility compliant before it is deregistered. The comment has already been addressed, and it is addressed in the Principal Act and the regulations as well as through the metrics. In terms of clause 15, in support of the proposed amendment, the following inputs were made. Clause 15 of the bill was supported, especially the insertion of 48 hours of obtaining a court order instead of 24 hours, since there is a shortage of magistrates and huge backlogs. of cases in the National Prosecuting Authority. 48 hours will afford the courts reasonable time to issue court order. The comments is noted by the department and it's appreciated. It has already received the necessary attention in the bill, and the bill already makes provision for 48 hours and not for 24 hours. And a further comment relates to older persons with disabilities and chronic illnesses, and that this should be that they should be protected from community-based care centers and friendly care centers and family members. And the department has noted the comment and appreciates the submission and states that the protection of older persons with disabilities has been addressed in the bill and in the earlier slides. And there is a section that is dedicated in terms of dealing with this matter within the amendment bill. Further comment relates to the fact that in light of the budget cuts across government departments, there are inadequate bed space in old age homes, and that this is worrying. The question is, where should the resources come from? Also, what safety measures will be put in place to ensure that the move is done in a safe and protected manner? The department submits that it has noted the submission and that the issue of funding has been addressed in the earlier slides and in the metrics, and that safety measures will be followed when moving older persons to temporary safe care without a court order. And that will be outlined in the regulations where further guidance will also be provided. A further comment relates to how will the expectation be managed regarding training and funding and the issues of better salaries. And the comment has been noted by the department, and the issue of training and funding as it relates to salaries. And the department has not been able to remove abused older persons to a place of safety due to lack of resources and residential care facilities. So the comment from the department is that it notes the submission and that the issue of the removal of older persons who are abused to temporary safe care without court order, including resourcing, funding such an activity, have been addressed in the earlier slides and in the metrics as well. An additional comment relates to the fact that it is particularly difficult for older persons with disabilities to access government services such as clinics, and that deaf people are not attended to when they visit government offices. The department has noted the comment and the issue of access to services by persons with disabilities and the challenges that remain relating to sign language interpretation have also been addressed in the earlier slide and in the metrics. And for clause 15 to be implemented, there should be provision for temporary safe care facilities in the communities, and the organization further states that it is difficult to place elderly people in old age homes that have subsidized beds. The department responds to this in that it has noted the comment relating to clause 15 and that the issue of funding and subsidized beds has been addressed in the earlier slides and in the metrics, and that there is a further submission relating to houses for older persons which should be remodeled to accommodate their disabilities. And the department has noted the comment and states that the building and provision of houses does not fall within the mandate of the department, and that the Portfolio Committee on Social Development has already brought the matter to the attention of the Department of Housing, Human Settlements, and that the Department of Human Settlements has committed that when the new houses are built for older persons, including older persons with disabilities, they will consider this recommendation and make sure that the necessary requirements are taken into consideration to respond effectively to the needs of the older persons who have got disabilities, as well as their varied other needs. Most older persons, especially those with disabilities and frailty, do not know their rights and services available to them. Most elder them. In terms of this comment, the department has noted the comment and states that it will be addressed through education, capacity building, and awareness campaigns, but that it will be necessary also to do targeted education and orientation and capacity building of the older persons across, the sector, to make sure that they understand all the issues relating to their rights and the services that they qualify to receive from all the providers of services. The next comment relates to abused older people that have been removed to the social clubs and do not receive any legal protection from the police, as they view it as domestic violence. Some elder people who have been removed feel abandoned and neglected as at the places of safety because they are far from their homes. After a few months, they want to go back home. The comment is noted by the department, and the issue of intersectoral collaboration comes back into the picture, where there is need for the Department of for SAPS as well as DOJ and constitutional development to be addressed in terms of the regulations, where the outlining of their roles and responsibilities as organs of the state to ensure the provision of the comprehensive basket of services to and programs to older persons will be dealt with in that regard. And we further say that services, including aftercare services for older persons who have been removed to temporary safe care without a court order, will also be outlined and further unpacked in the regulations. Now, there's a further comment, there's a further recommendation, and which states that there should be sign language interpreters in all government sectors, at police stations, at courts and churches, and in other front desk offices. And the comment is noted and appreciated, and the provision of a sign language interpreters will also be done by all organs of state, and the needs of older persons should also be considered as this gets to be executed. There's an additional comment that relates to transport for older persons, as there are vehicles that are designed to transport people with disabilities. And the department has noted the comment and states that the provision of transport vehicles designed to carry older persons will have to be discussed with the Department of Transport for collaboration, as transport falls outside the mandate of the Department of Social Development. However, improvements in this regard are known, as they have also been observed in various other countries where there are adjustments relating to buses and other services that relate to transportation of older persons that have been given the necessary attention for adjustments. In terms of Section 25A, there's a submission that this section should be amended to provide that the court may not grant an order unless it has obtained a report on circumstances of the older person concerned from a social worker or a healthcare provider. And the department has noted the comment and has included this in the matrix, and it will also be addressed in the regulations as they will be developed. And there's a further comment relating to houses for older persons that are still going to be built. And I think this slide is a repeat of the other, is repeating the same information as the one on the other slide. and that there is also a comment that relates to the support for the bill, and a further comment relates to the fact that the Act does not define substance referred to Section 25(5)(e), and that it is proposed that a definition of substance be included in line with the Prevention of and Treatment of Substance Abuse Act 70 of 2008. And the department has noted this comment, and it has addressed this matter in the matrix as well as in the earlier slides. There's comments relating to clause 16 of the bill, which was supported, and the following inputs were further made: that police officers take longer to arrest, and that furthermore, it is alleged that police officers do not take cases of older persons abuse seriously, especially if a perpetrator is a member of the family of an older person. And the department has noted these comments, and the Act outlines responsibilities of police officers, and more guidelines will also be included in the regulations to ensure that the roles and responsibilities of police officers and subs are clear and enforced through the national instructions that they normally issue once such regulations have been concluded, and this will be strengthened rules as well. Police officers should be the guardians of the rights of older persons and should take cases of older persons seriously. In terms of this submission, the department has noted the comment and states that the roles and responsibilities of subs and police officers will be further unpacked and outlined in the regulations. There is a further submission relating to the fact that there are no private rooms for older persons when they get to the police stations to report any matter that impacts on them, in order for them to freely express their challenges and the situations that affect them. And it is therefore recommended that a private room is needed when older persons open cases, especially issues of sexual assault. Appreciated the submission, and it has been included in the matrix, and that the new clause to include the private rooms will also be inserted in section 26(6), and that with regard to a further submission linked to complex, they should receive special training in order to understand the challenges faced by older persons, and that some older persons are struggling with disorders such as dementia. The department has noted the comment and appreciated this submission in the matrix, and submits that training of all practitioners, including court clerks, will also be included in the regulations to ensure effective and optimal implementation of this legislative framework. In terms of the submission made relating to the abuse of older persons, do not want to report their abuse to the police. They report the abuse to the caregivers, but when caregivers try to intervene, older persons would report them to their families, and this causes problems for caregivers as families accuse them of interfering in older persons' family affairs. The department has noted the submission, and this matter will also be addressed in the regulations and during the implementation through training and capacity building and awareness campaigns on elder abuse that will be conducted with all key stakeholders. And there is a new proposal which is not in the bill. The word may should be submitted with must. The department has noted the comment and states that despite the fact that this was not gazetted, the proposal is supported. We stand to be guided by Parliament as to whether we can also amend this part as it was not substantive, but more administrative in nature. And the next comment relates to the insertion of a provision similar to sections 29.2 with regard to section 27.5 relating to the inquiry after section 27.5, and that it should read as follows: the magistrate or any other person designated by the magistrate for the purpose must appear at the end of the inquiry and may call witnesses and cross-examine any other witness giving evidence at the inquiry. And the department's comment is that it has noted this submission and that although it was not gazetted, the proposal is supported. And we further stand to be guided by Parliament as to whether we can also amend this part, as it is not substantive but more administrative in nature. Further submission relates to the abuse of an older person, where there is an assertion that an older person, the abuse of an older person is a criminal offense in terms of section 31, and that the proceedings in section 27 to 29 are not criminal proceedings. They are inquiries into the alleged abuse of an older person, and therefore the word alleged offender should be substituted with alleged abuser. Once the alleged abuser has appeared in court, he or she is simply referred to as the respondent. Now, the department has noted the comment and states that despite the fact that this was not gazetted, the proposal is supported, and we stand to be guided by Parliament as to whether we can also amend this part. Further submission relates to the powers granted to the court in terms of section 27.6D, which should be included in section 29.10. The department has noted the comment and submits that despite the fact that this was not gazetted, the proposal is supported, and we stand to be guided by Parliament as to whether we can also amend this part, as it is not substantive but more administrative in nature. And the insertion of section 29.10C should also be as follows: make such other order with regard to the matter as the court deems fit. That is the proposed change. And in terms of clause 17, this provision has been submitted to be akin to other provisions in other legislations wherein a prosecutor plays a role in a procedure of this nature. And DSD submits that it has noted the comment, and that although the department supports the proposal, the relevant organs of state, namely DOJ and Constitutional Development and the NPA, have an upper hand on the matter, and this bill is not intended to assert their powers. There is a recommendation that states that the courts should be brought closer to communities so that they can be accessible to older persons. And in this regard, the department indicates that it has noted the comment and will be brought to the attention of the relevant organs of state, namely the DOJ and Constitutional Development and the NPA. And important to mention is that we are working quite well with the Department of Justice and Constitutional Development and the NPA, and there's a lot of work that we've already done together in preparation for the finalization and implementation of this legislative framework. In terms of section 28.1, there's a submission that states that there should be replacement of if a social worker or a healthcare practitioner with if any person. The comment is noted and appreciated by the department. However, the proposal is not supported, specifically because section 25 and section 26 already make provision for any person to report suspicion of elder abuse. However, section 2 or court purposes. There's a further comment relating to a proposal linked to section 28.10, that once the affidavit is received by the prosecutor, he or she can then request a report from a social worker in terms of section 28(2). The comment is noted and appreciated. However, the proposal is not supported. There is no provision made for section 28(10) in the bill, and thus the comment is not clear. A further comment relates to the bill that it should address the issue of legal representation of abused older persons in court, and that it should also expedite the allocation of special court rooms and specialized personnel to deal with abused older persons. And the department's comment is that it has noted and appreciated this submission, and it has also been addressed in the bill, and this will also be included in the regulations to provide clearer guidelines on court services available for older persons, working very closely with the Department of Justice and Constitutional Development, as well as the NPA. We have also noted the progress that the Department of Constitutional Development and Justice have already done in terms of the allocation of special court rooms and specialized personnel to deal with abused older persons, as well as subs to this effect. There is also a comment relating to the provision of section 29(2) of the Principal Act, which empowers the magistrate to designate a public protector or any other person to appear at the inquiry. The magistrate cannot by law designate a prosecutor to perform prosecutorial functions. The literal meaning of the word designate is understood to mean appoint, assign, or ascribe. The question of interest is, who is this any other person that the magistrate could designate to participate in the judicial process? Is there any guidelines on the suitability and competency of this any other person? And this is a new proposal that is not in the bill, which is within section 29(10)(b). And the recommendation is that there is no justification why the duration of an order in terms of section 29(10)(b) should be restricted to 10 years, and so the restriction should be removed. The comments are noted and appreciated. However, the matter was not gazetted for public comments. That is the submission by the department. There is a further submission which relates to the powers being granted in terms of section 27(6)(d), that it should be included in section 29(10). The department notes the comment, and there's a further comment that relates to the insertion of a provision similar to section 29(2) with regard to section 27(5) in terms of the inquiry after section 27(5), which it is proposed that it should read as follows: the magistrate or any other person designated by the magistrate for the purpose must appear at the inquiry and may call witnesses and cross-examine any other witnesses giving evidence at the inquiry. The department states that it has noted this comment and it has been considered and included in the matrix. In terms of clause 18, there's a proposed amendment. There's an indication that the proposed amendment was overwhelmingly supported, and the following inputs were made. Support the insertion of a court clerk or register to record the physical abuser of older persons by providing the details of the offender who have been convicted. And the comment by the department is that this has been noted, the submission has been noted and appreciated. And it will be further unpacked as indicated earlier on when we deal with the clarifications relating to issues that need to go into the regulations. And there's a further submission relating to the keeping of the register of physical abusers, which will ensure the protection of older persons from perpetual offenders. The department has noted the comment and has appreciated the submission. A further comment relates to the fact that there must be consequences for the perpetrators of older persons abusers. It is also proposed that life sentence be issued for the perpetrators. The department has noted the comment and appreciated this submission. However, it is not supported as it does not fall within the mandate of the department. The proposal will be escalated to the relevant organs of state, which is namely DOJ and Constitutional Development and the NPA for consideration during their legislative reviews. And as we have done with the many other areas of concern that we had, and which are receiving the necessary attention. And the South African justice system should also protect the older persons and speed up the court proceedings. And the submission has been noted and the comment is appreciated and will also be escalated to the relevant organs of state and the DOJ and Constitutional Development and the NPA specifically. And we need to indicate that we're noting the immense progress that they have made relating to the engagements that we have had with them relating to the very same legislative framework and the proposed changes. And there's also comments that have been submitted relating to older persons, particularly the frail that are abused and neglected by their family members, in home-based care centers, frail elderly people that are abused by older persons themselves, and more the reasons that they are abused, and older persons that are financially abused by their families demanding their old age grants. The department knows these comments and state that the elder abuse has been addressed in the Principal Act and in the bill and will be further outlined in the regulations, where clear guidelines will also be given in terms of how to deal with issues of elder abuse by both older persons themselves as well as our key stakeholders. And there's a further submission that states that there's a lack of clear definition of statutory abuse of older persons in the bill. When the older persons are deprived of necessary services, such as the recent delay of payments by SASSA, there is no consequence management, and that matches this transgression. And this was a statutory abuse, but there's no provision of such statutory transgressions in the bill. The department noted the comments, and it must also be remembered that the abuse is defined as being physical, emotional, and psychological, to mention but a few forms thereof. Further submissions relate to older persons feeling neglected by government because they have to travel long distances in order for them to access government services, but they are also abused by their grandchildren who are unemployed and use drugs, and especially those older persons who come from rural areas and feel neglected as they do not access any services and facilities. And to this effect, the department has noted the comments, and the issue of elder abuse has been addressed extensively in the Principal Act as well as in the regulations and in the metrics, and will be further unpacked and included in the regulations as we prepare for that. And the roles and responsibilities of organs of state provide services to older persons who are abused in line with their core mandates as organs of state. Further submission is that there is a great need for old age homes in communities. The department notes the comment. However, the need for more residential facilities should be informed by the needs analysis and availability of funds to build more facilities within such communities. And it should also be noted that the Act currently promotes that older persons should remain in communities for as long as it is possible. And therefore, more resources should also be channeled towards strengthening of community-based care and support service centers to ensure that there are serious improvements in this space as many families get to prepare themselves to start being the primary caregivers of their older persons. And recommendations that have been submitted relate to punitive measures that should be inserted in the bill for the physical abuse of the older persons. and the department knows the comment, and it will be addressed in the regulations further, unpacking what all these measures will be and in what form will they be coming, and what the implications will be for the physical abusers of older persons. Further comment, section 32 of the act to add occurring within a domestic relationship and outside the domestic relationship. And the department knows this comment and has further unpacked and addressed it in the matrix. A further comment relates to psychological abuse in section 33, and the proposal is that it should read as follows: emotional, verbal, and of psychological abuse, which means a pattern of degrading, manipulating, threatening, offensive, intimidating conduct towards an older person that causes mental and psychological harm to an older person, including repeated exhibition of obsessive, possessive, or jealousy, which is such to constitute and as such constitutes a serious invasion of the complainant's privacy, liberty, integrity, or security. The willful damaging or destruction of property in close proximity of a complainant to harm or threaten a house, pet, or other animal whose welfare affects a complainant's well-being, a complainant's well-being. To disclose or threaten, to disclose a complainant's sexual orientation or others without the complainant's consent, to threaten the complainant with death or injury of a person or damage of another person's property, or threatens to commit suicide or self-harm. And that there's need to add definition of harassment in section 33 to be in line with the Domestic Violence Act number 116 of 1998 and its Amendment Act.
Civil, excuse me. When do you think we'll finish? It's more
in the
than
next
an hour.
3 minutes.
In the next, how many?
3 minutes. Oh. There are only 5 slides left. We're done.
Please.
3 minutes, okay. So in terms of the definition of abuse, there's a proposal that we should insert this phrase that states occurring within any relationship where there is an expectation. Department has noted the comment and it has been addressed in the matrix. A further comment relates to spiritual abuse and its meaning. They state that advocating hatred against the complainant because of their religious or spiritual beliefs that constitute incitement to cause harm to the complainant, as well as preventing the complainant from exercising their constitutional rights to freedom or conscience, religion, thought, belief, and opinion. The department has noted the comment and it has included it in the matrix. A further issue relates Further issues relates to service delivery, and we have tried to summarize this up. There is a concern relating to government pensioners. Government pensioners should also receive old age grants as they are entitled to it as older persons. And this means the issue of means test, this empowers older persons when they reach pensionable age, and it creates conflicts. It has also been addressed earlier. The department has noted this comment. However, it also falls outside the scope of this bill. And as indicated earlier, it has been brought to the attention of the relevant team. And in terms of social assistance program, there's a comment relating to the old age grant, that it is used to financially support children and grandchildren because of high unemployment rates in the country, and that it should be increased. And the issue of older persons getting robbed while standing in long queues at pay points or while traveling back home after receiving their grants. And most older persons do not know about the granting age, and especially the education campaigns organized to educate older persons about this grant, and linked to that, there should be a specified age, for example, 70 years older, which is able to automatically qualify for this grant in aid, for people to support them with the execution of chores and self-care. The department has noted the submission, and however, this also falls within the scope, does not fall within the scope of this bill and the principal act. And be that as it may, the relevant land functionaries within the department have been advised of this submission, and the matter is receiving the necessary attention. And in terms of public participation platforms, the older persons across the country should be given a public platform to be addressed by the president, and this will show that the president also cares for older persons. The comment is noted and appreciated and has been elevated to the relevant authorities. And in terms of government services, such as clinics and courts, this should be made accessible to rural areas through mobile trucks. And we note the progress that the Department of Health has done in this regard, and there are plans that are in the pipeline to respond to this, including the issues of chronic medication, especially for older persons. And the comments have been noted by the department, and further work will be done. And then there's an issue relating to funeral schemes. Government should establish a public funeral scheme for older persons because they cannot afford open private insurance policies within the limited old age grant. The comment is noted and it has been elevated to SASSA for consideration and further management. And finally, Chairperson, it's about the issues of service desks for older persons. Older persons should be represented in Parliament through the establishment of an older person's desk, similarly to the one that is located in the Premier's offices, and that there should be representation of older persons in ward committees. The comment is noted, and it has been elevated to the relevant authorities and organs of state. And the late notification on public hearings, there was a concern raised in this regard, and speakers expressed their disappointment to this effect, and this deprived service centers and other relevant organizations from submitting meaningful inputs and comments, and some provinces did not receive copies on time, and these were also not translated into local languages. And the comments have been noted by the department, and there's a further need for both the department and the portfolio committee to work closely with the mobilization units within Parliament when public hearings are being prepared for. So non-attendance of stakeholders who were consulted on the bill should have attended the public hearings. It was important for them to attend the public hearings because they provide services to older persons. And the comments are noted and appreciated and will be further elevated to the relevant authorities and organs of state. And let me take this opportunity, Chairperson, to thank you for your patience and for accepting to listen to us whilst we deliver this very long presentation. And let me also officially announce that the active aging program will be taking place in Mpumalanga from the 20th to the 23rd of March, as older persons had requested. Thank you very much, Chair and honorable members.
Thank you, Cyril, and thank you, the team. Then let's engage with the presentation. It has been dealt with clause by clause, and also we need to deal with the deliberations and be able to get into the next stage of the bill. Let me recognize hands. I wonder, are the people still on? Now that the challenge of the network is very, very challenging, really.
Chair.
I see only another
Chairperson.
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 Honorable
Yeah, thank
Hello.
you. Did you recognize me?
I beg yours?
Can I speak?
I'm still
Chairperson?
recognizing. Yes, you can
Oh.
speak.
No, I was just thinking, and afternoon Chairperson, I was just thinking of the presentation were very lengthy, and I'm looking at the time, it's like 1 o'clock, and we need to be in the house at 2. So I actually want to make a suggestion that if the members have inputs, that we rather do it in writing to the department than us engaging now on this presentation. It's just a proposal from my side. Bear in mind the time, it's 1 o'clock.
Yeah. I'm also looking at the time. That's why I was really panicking. And I can see other honorable members have been kicked by the
Yes. Yeah.
network,
Yeah.
and others have to travel to the
Parliament.
house, and also, yes. Now, there is a proposal that let's do the, what is it, written submission to the department, and yeah, I don't think we've got a problem on that, because the reality of the matter, the department has responded to all those that they think that they need to respond, and to all those that they don't have any other questions, they are saying noted, noted. We have noted, we have it, yeah. The only one that we have to comment is the one that they are also saying we have suggested, or we have taken the suggestion from the public hearings. We agree with it. So maybe if we can, I noticed that we have been sent for by the department some clauses, and they highlighted those that they have agreed and highlighted them with the yellow highlight. So it is going to be easy for honorable members to just look at those that have been highlighted and agreed by the department. Otherwise, there's not much that we have to refuse and deny, or have some other ideas on it. I was also asking myself that the professor from Western Cape University also had an idea in terms of an argument of saying caregiver is this and that and that and that. So there are those that maybe need clarification, and also there are those that we have also to note to them. Can we then get someone who's saying, okay, let's write a submission, or let's do written submissions and highlight them. And before the meeting starts, the next one, that is tomorrow, we will get the indication. So we don't have much time to do this written submission. It will be only this afternoon and evening, so that when we have the meeting tomorrow, we are being presented. Can I get the indication? Okay. Hey, there's no other hand, meaning that it's myself and Honorable Aris that are in this meeting. Serious. Abraham P. Who's that? Abraham P. Because there's also.
Is it not Alex?
Well,
that's not me, but I'm happy to be back.
Welcome, welcome, new mother to the new world.
Thank you so much.
How is it to breastfeed?
not a topic for this platform. Maybe when I see you in person. But it's been going well, and I would support Honorable Ari so that we can get to the House at 2 o'clock. Thank you, Chairperson.
Yes, thank you, Honorable new mother in the new South Africa. Thanks ever so much. It has been seconded that let's do the written submission, and also in the meeting that we will have those that have been highlighted and also agreed upon or disagreed upon with, so that you can focus and not dwell with all these clauses that we all agree upon. Can we then, I see the hand of the portfolio committee man who is a host. I think it's Lindy.
Yes, Chair.
Over to you.
Okay. Thank you very much, Chair. I would like to outline the procedure going forward. And now that a decision has been taken for any clarity-seeking questions to be forwarded to the department to provide clarity. Chair, should be any questions to the department. Tomorrow we were supposed to do the MOD and the public hearings report, and to have a deliberations on the bill. Now that there is this change, it requires the committee to amend tomorrow's program a bit. Firstly, for the department to respond if there is any clarity-seeking questions. And then secondly, Chair, in terms of the process or the procedure to process any bill, a committee is required to ensure that all the work that has been done is considered and adopted. So we have one report that is outstanding for the committee to move to the formal stage of the bill. So we will adopt the report on the public hearings held in the virtual platform. That is to finalize all the work that has been done by the committee. And then thereafter, there is a motion of desirability that the committee must consider and adopt before it can deliberate on the contents of the bill. And then after the report on the public hearings, the committee will proceed to adopt the motion of desirability. And then after that, the committee will be at liberty to discuss the bill in detail. So, Chair, after that, the deliberations on the bill will ensue, which means that the committee will be at the liberty to use the matrix by the department. I think it's a useful tool for the deliberations, as well as the summaries and the bill itself. So after that, you will be able to deliberate and agree on the proposals from the department, and any proposal that the committee would deem fit for it to put in this bill, depending whether such amendment is implementable or not. So I thought it's important just to outline the process going forward, that we're going to do those stages in terms of complying with the rules and the procedures of processing the legislation. Thank you very much, Chair.
Okay, Lindy. Thank you for that reminder. Anyway, we definitely have to give over to the department first, definitely, if we are saying time is against us on this, and also follow other processes that we have outlined on the same day and the same blend. Same, I will say same whatever, but let's agree upon on it that we don't have to, we have to hurry and rush it, but we have to also to follow all the steps that are necessary to be followed, which now we are not finished yet in terms of engaging in this so as to agree. Let's allow and give time for that before we start. In fact, before we continue with other processes of the bill. Thanks ever so much. You will also remind us again, Lindy, you will not get tired because we might as well skip some of the procedures and processes, but we'll keep on reminding us, put this is the next one and that is the next one. People now have to rush for the meeting because it's a 3-line whip meeting. I agree with you. Honorable members, can we say, let's adjourn to the meeting and thank the officials that have managed to assist us in terms of discussing this. It was not an easy deliberation. It is a long and lengthy, but we don't have a choice. We had to deal with clause by clause. Thank you very much, officials.
Chairperson, my apology. There's just a point that we want to raise with your permission, please. Civil will raise the point, but we've accepted all the recommendations and comments, and we'll be ready tomorrow upon receipt of the questions of clarity. Civil?
Chairperson, thank you very much. I just wanted to indicate our response to the fact that there are areas where we kept on indicating that we have noted, comment is noted. It is only for those areas where it was just submissions that did not require response. So we were noting those because some people appreciated the work that was done and welcomed certain sections and subsections of the legislation and indicated and confirmed that this will assist us to move from point A to point B. So we were simply acknowledging and appreciating the comments. We responded.
Exactly what civils, just not allow you to elaborate more. That's how I understood it. And that is why I said that those that have been noted, it's the one that we are on agreement with the submissions, with the public hearings, with us. We agreed with the department. It's said, noted, so there is no argument on them. I've indicated that in the meeting. So I don't think it's a transmission saying noted. Was just highlighting and trying to caution the members that those ones that noted, we are all in agreement on it. Those that have submissions, and also the department is also saying that, yes, we are nodding on it. It's exactly those that maybe they need some clarification, if there is any. It doesn't mean that it's supposed to have those clarities, but it's just that those that are in need of the clarification we do. If there is anything that we think we are against, if anything that we agree, we are also not going to deliberate on those tomorrow before we get into the next procedure that will be tomorrow. Thank you very much, Kumbula. I don't think there needs to be any deliberation now because of time. Let's see the honorable members, the ones that have been kicked off by the network and those that have been requested to be recused. Then we check on those. We might get comments and also clarifications, but we might not get anything. That will be okay, but we don't want to skip a stage of not deliberating and getting to understanding one another. Thank you. Thank you very much. Thank you very much, honorable members, those that have managed. It is not easy. For the first time now, I'm also not disadvantaged by the network because I'm just being assisted by the Wi-Fi that I've operated and on. Otherwise, this thing of network really hampers us and disturbed us. But thank you very much for the officials that have managed to assist us in presenting this bill. Thank you ever so much. See you tomorrow. The meeting is officially adjourned. Thanks.
Thank you, Chair.
Thank you. Lindy, you can close the meeting for all of us. Let's quickly. It's a 3-line whip. No one has to excuse themselves. If we have to vote, we'll vote. If we don't have to vote, it's okay. Thank you.
Thanks,
Close
Chair.